Please rise. The Justice of the Appellate Division, Supreme Court, First Department. Hear, all persons having business with the Appellate Division who are near, give your attendance and you shall be heard. Please be seated.
Good afternoon, lawyers. Welcome to the First Department. I will begin with a call of the calendar. And it's so great to see people other than in the screen. So good to see you all. People versus John Carlucci. Appellant has been given 6 minutes and 2 in rebuttal. The people have been given 6 minutes. Second case on the calendar is Skeptic versus SL Green. Appellant FRP sheet metal, I understand, still wants to argue and will argue for 5 minutes. Respondent structure tone wishes to submit. H. Alexander is submitted. Zubiaga versus Finley Teller. Appellant Zubiaga gets 5 minutes and 2 in rebuttal. Finley Teller respondent gets 5 minutes. Tioso versus Dangin and Lenz Cap. Lenz Cap has submitted. Appellant Tioso, I understand, wants to argue. We'll give him a few minutes. People versus Catlett. Appellant Catlett gets 6 minutes and 2 in rebuttal. The people get 6 minutes. FGP1 v. Dubrovsky, M Investments, and Pirogova. So let's see if we can sort this out. Appellant M Investment gets 6 minutes and 2 in rebuttal. Pirogova cross appellant gets 6 minutes and 2 in rebuttal. And respondents FGP1 gets 6 minutes. As long as they're not repeating each other's arguments, then it's less time. People versus Quiñones is submitted. 322 West 47th Street versus Guarino. Guarino appellant gets 6 minutes and 2 in rebuttal. Cross appellant 322 West gets 6 minutes and 2 in rebuttal. P. Maxwell is submitted. People versus Miranda is submitted. Arch Insurance versus Petrocelli. Appellant Arch Insurance gets 6 minutes and 1 in rebuttal. Petrocelli respondent gets 6 minutes. Worthy Lending versus New Style Contractors. Appellant Worthy gets 5 minutes and 2 in rebuttal. New Style Contractors gets 5 minutes. People versus Martin. Appellant Martin gets 5 minutes and 2 in rebuttal. The people get 5 minutes. And last, State of New York versus Brown. Petitioner gets 5 minutes and 2 in rebuttal. Brown respondents gets 5 minutes. So first case on the calendar for argument is People versus Carlucci.
Step up.
May begin.
Good afternoon, Your Honors, and may it please the Court. Sarah Cravens from Sullivan and Cromwell, pro bono counsel with the Office of the Appellate Defender, appearing on behalf of Defendant Appellate John Carlucci. Any convenience gained by the consolidation of 6 charges in this case was vastly outweighed by the prejudice it caused to Mr. Carlucci. Because, as Mr. Carlucci predicted in his pretrial motion, the events that unfolded at trial made it substantially unlikely that the jury could separately consider the evidence as it related to each offense. The strength of evidence varied widely for each of the 6 incidents, and the prosecution did everything possible to get the jury to conflate the evidence, starting with the...
But is it really, is there any material variance in the quantity of the proof? And isn't it easily segregable to the juries? I mean, a jury can figure out what evidence pertains to what charge, no?
Respectfully, no, Your Honor, because the strength of evidence here varied widely. Some of the cases involved DNA, and some just involved low-quality video surveillance that didn't even show color. So even if that video has some probative value, that would be orders of magnitude weaker than the more reliable DNA evidence. So the problem is that this variance of evidence made it more likely that the jury used stronger evidence to...
I mean, the video, in the video, defendant can easily be identified, right?
No, Your Honor. The defendant, the face maybe shows for a split second, but the picture quality is very grainy. In some videos, it's washed out, and for most of the time, he's not even facing the front. So I'm not saying there's no probative value at all to these videos, but compared to the DNA evidence, asking a jury to identify based on poor videos...
Counsel, wasn't there clothing recovered that also matched the clothing worn by the individual in the video?
Yes. But that clothing, it was generic clothing. There weren't many identifying features. It could have been worn by anybody, and more importantly, that the videos did not show the color of the clothing. That clothing evidence could have been easily introduced separately without reference to any of the other incidents. And even if the clothing was used to show that the same person appeared in multiple videos, the jury still had to decide whether that person was Mr. Carlucci. And the risk that they conflated that weak video evidence and clothing evidence with the stronger DNA evidence, that risk is high because of the sheer number of incidents involved here and the propensity statements made by the prosecution. Even in the opening statement, the prosecution started by explicitly telling the jury to collectively consider the evidence, to find that the defendant committed a pattern burglary of all 6 locations. Then, the prosecution presented the witnesses out of order and ended with a closing statement riddled with assertions about the defendant's propensity to commit crimes, such as the defendant was not shy about committing multiple burglaries on the same date. He doesn't hit one spot, he goes big. He hits multiple locations, and he's not afraid of locks. These are not statements about what Mr. Carlucci did. They are statements about who he is and what he does. Classic propensity statements that reinforce the jury's natural tendency to consider propensity. It already stretches the limits of fairness to combine 2 or 3 incidents into one trial, but courts have upheld those consolidations when there was some indication that the jury did not convict on propensity. Here, there was no such indication. These charges involved different types of evidence, manners of entry, tools used, items taken. There were no common eyewitnesses, and some of the burglaries happened a year apart. And yet the jury convicted on all 6
Wasn't
crimes.
there other overlapping evidence?
Some of the evidence, again, like the clothing and the videos, could have been overlapping. But the point is that the sheer number of variables here suggests an extremely high risk that the jury took shortcuts and used the stronger cases to conflate with the weaker cases to convict on propensity, especially after they were told to consider the evidence collectively, and after they sat through an entire trial of muddled, disorganized evidence and propensity statements. Each case might be straightforward enough on its own, but multiplied by 6, it's no longer straightforward. Just in terms of what the human brain can keep track of, it's difficult for anyone to keep straight 6 separate sets of evidence and make 6 decisions simultaneously, especially when it's being presented in a confused manner. So all of these acts, the propensity statements, the muddled evidence, and the explicit statement to consider evidence collectively, this created a substantial risk that
Counsel,
Mr. Carlucci...
What do you mean by muddled evidence? What are you talking about? What
Your Honor,
muddled evidence?
I just mean that the witnesses were presented not in order of crimes. They were presented maybe for the first crime, and then the third, and then the fifth, and then the second. The witnesses went back and forth.
Why is that muddled?
I just mean it's out of order. It's out of order, meaning that it was even harder for the jury to keep track. So if the evidence had been presented in a clear fashion, that this evidence belongs to this crime and you should consider it separately, that would be a different story. But here they were presented in random order and told to consider the evidence collectively. The second issue in this case is that as a matter of law, no burglary that Mr. Carlucci was convicted of was a burglary of a dwelling. So his second-degree burglary convictions were legally insufficient and unsupported by the weight of the evidence. And we would submit that a close analysis of the McRae court shows that only third-degree burglary was warranted here. Thank you.
Thank you.
Good afternoon, Your Honors. Franklin Gunther on behalf of the people, and may it please the court. Defendant's conviction should be affirmed. Beginning with the legal sufficiency and weight of the evidence claims, People v. McRae provides that under the applicable statute, if a building contains a dwelling, a burglary committed in any part of that building is the burglary of a dwelling. Here, two of the buildings that defendant burglarized, Sunrise Laundromat and San Mateo Pizzeria, house living quarters under the same roof, and therefore defendant's unlawful entries clearly constituted second-degree burglary.
Counselor, let me ask you, the defense counsel spent most of her time arguing on the issue of the consolidation. And I mean, with two cases, I get it, but here there were a few different indictments dealing with 6 separate incidents. How honestly could even a very committed group of jurors, and I find most jurors usually are, separate all that and not somehow in their mind, without even intentionally meaning to, not conflate some of this evidence that came in throughout this trial?
Well, the only indication that, the only way that there would be prejudice in this case is if, as Your Honor noted, there's a substantial likelihood that the jury could not separate the evidence, and there has to be a material variance between the evidence on the different charges. So although the 2015 burglaries were the only ones that contained DNA evidence, all 6 were captured on video evidence. And those videos were presented in conjunction with the witnesses who either worked at those establishments or who, or sometimes in the case of the investigating detective. I would also note that there was other physical evidence overlapping that actually supported multiple convictions. Defense counsel noted that the sweatshirt that was recovered from the defendant's apartment was the color was not visible, but that piece of clothing actually had distinctive markings that were visible in multiple videos. Although the cases that were cited usually...
You said that there was distinctive markings, because counsel said it was generic clothing.
It's actually not generic, especially with pertaining to the hoodie, which was seen in the Asian 83, Blondie's burglaries, as well as the San Mateo burglary and the Numero 28 burglary. In all of those videos, in the case of the Numero 28 burglary, you can see that it's red. In the other 2 videos, you can actually see both the zipper pocket on the left side of the chest, and in both cases, the zipper was undone slightly so that you could see the distinctive markings on the inside. I'd also note that the hat, which was recovered from the defendant's apartment, was seen in both the Asian 83 Blondies video as well as the San Mateo video. Defendant's flashlight, which was recovered from his apartment, was seen in the San Mateo burglary. And to the extent that there are multiple videos, again, they're all presented...
Were they all the same quality? I know, like, the Green Cafe video, I mean, counsel talks about it being very grainy, but can defendant easily be identifiable from those videos?
He absolutely can, Your Honor. Even in the Asian 83 Blondies video, which is the one that's sort of removed and it's in an alley and you can't see it's because it's farther away, you can still clearly make out the defendant's face in all of these videos. And the jury was able to compare those videos to the arrest photos taken at the time that the defendant was arrested shortly after these 2016 burglaries. So the idea that the jury wouldn't be able to...
Detective Guerras testified before them, right? Before the jury.
I'm sorry, Your Honor?
The detective,
Correct.
Guerras,
Yes.
he testified because he's the one who kept talking about, the person shown in the different videos are the same height, body type, body style. So he actually testified before the jury. Right?
That's correct, Your Honor. He was the investigating detective on all of these crimes, and he was able to testify as to not only the way that defendant's appearance had changed since the time he had committed the crimes, but also to help the jury understand this video pertains to these incidents, this video pertains to these incidents. And again, the employees that worked at these establishments also testified along with the videos. And especially in the case of, for example, the laundromat, there's no question that is a laundromat. And to the extent that any of them else shared characteristics by being in a basement or in an alley, the employees who worked at those various establishments were able to testify as to, yes, this is where I work and this is the basement. He's going into the office.
Well, it's kind of confusing because Mr. Lin lives right above, the owner of the laundromat lives right above it, right?
That's correct. And that goes to the second degree burglary. I see my time is up, but
Yeah, you got 30 seconds.
I see that, as you noted, the owner of the laundromat lived above lived above in the residences. He had a key to the basement. Both of the buildings that constituted second-degree burglary were nothing like the Joseph case, which involved a sidewalk hatch that's totally unconnected to the buildings above. Here, there was access through the doors interior to the dwellings, and for those reasons, those convictions for second-degree burglary should be affirmed, as well as the other counts.
Thank you.
Thank you very much, Your Honor.
And Ms. Freeman, you have 2 minutes.
Thank you. The video surveillance was not as clear as my opposing counsel would argue and suggest. And the point is, even if the videos had some probative value, they were vastly different from the stronger cases where there was DNA evidence. And it's important to note that the only common witnesses among these cases were police officers who investigated after the fact. No eyewitnesses were common, and no eyewitnesses could even identify.
So you're still dealing with the consolidation issue, but you agree that that's a discretionary decision by the trial judge, right? So we
Yes.
review that decision under an abuse of discretion standard.
That's correct. Yes, that's correct. And we would argue that because of the sheer numbers involved here, that decision had to have been an abuse of discretion. And on the dwelling point, the McRae court held that if the residential area of a building is remote and inaccessible from the non-residential area, and if a defendant enters from the street into the non-residential area and doesn't even enter a stairwell that has access to the residential area, that can only be third-degree burglary. Now here in the laundromat, there was a single locked door just near the entrance that the only thing that the prosecution can point to support second-degree burglary. But there's no evidence that this intruder had any tools that could have broken through a locked door, and no evidence that
Do we know that it was locked? Is there any evidence?
Yes.
Trial that it was locked?
Yes, there was testimony that the door would have been locked at that time. And there was no tools that the intruder had that could have broken through the door. And there was no locked doors involved in this case. The intruder entered through an open
Counsel,
window.
even under Joseph, which is the case you rely on, I thought that it has to be a large space. It's not so much the absence of a door or a locked door, but rather that there's lengthy spaces between the dwelling areas and the place burglarized.
So we would rely more on the McRae case. Space is one aspect that has to do with remoteness. Those are the two questions, remoteness and accessibility. So in both of these buildings, there were several stories between the basements where the robberies occurred and the residential apartments stories above. In the laundromat, there was no way to get through that locked door. And in the pizzeria, there was testimony that even if both locks from both sides of the door had been removed, that door could barely budge, and so that also was not accessible. Thank you.
Okay, thank you. Ms. Freeman, please thank the Sullivan and Cromwell firm for the services that you provided today, and thank you very much.
I may be wrong.
Okay, counsel, you have a few minutes.
Thank you. Good afternoon. May it please the court. Allison Snyder with Fabiani Cohen and Hall for the Appellant FRP Sheet Metal Contracting Corp. I don't want to take up too much of the court's time because I think that we have addressed all of the issues in our brief. The one thing I did want to highlight, just because I'm not sure that it was as clear, was when we were referring to the different indemnity provisions, specifically the blanket indemnity agreement. We had referred to that as saying that, if Structure Tone had intended for the work of FRP subcontractors to be covered as part of our indemnity obligation, that they could have said so. I'm not sure if it's as clear that was literally part of the terms and conditions. There were two indemnity provisions. The first one is the one 11.1 that says that if there is a blanket indemnity agreement, that's the one that controls, and if not, then this other indemnity provision controls, which is the one that's at issue. That's 11.2, that specifically says that FRP is only obligated to indemnify for any claims that arise in connection with the performance of any work by subcontractor, and that's FRP, pursuant to the purchase order. Now, the purchase order only...
That's the exact language, right?
It's the exact language, and that's the extent of the language. It begins and ends with the
That
performance
means
of any
all
work.
of the work, right?
It says a performance of any work by FRP. This is in accordance with the intent of the parties. This particular, there were two purchase orders that were issued, one for sheet metal, one for the mechanical work. And if the plaintiff had been a tin knocker, if he had been doing sheet metal work, then absolutely it would have been covered.
But Structure Tone did contract with your client for both the wet and the dry work, did it not?
Well, it issued the purchase order for the...
No, but I'm talking about, wasn't there a written contract as well?
There were two, and there was an agreement that we would perform the sheet metal work, yes. And in that situation, if the plaintiff had been a sheet metal or if he had been a sheet metal worker, then his claim would be covered. We would be obligated to indemnify him because it would have been a claim that arose out of the performance of the work that was performed by FRP, but he wasn't. He was a pipe fitter, and that was not work that could be done.
Isn't there also language that indicates that FRP is bound to Structure Tone for the performance of the work in the same manner as Structure Tone is bound to the owner?
I'm not aware of that. There was a
That's the record at 209. So
well, the full scope of the indemnity is for any acts or omissions that, including anything that was done by FRP or its subcontractors. But that's not the triggering. You can have a large indemnity obligation, but it has to be triggered by an act. And we know that if Structure Tone had intended for FRP to be bound by the acts of its subcontractors, all it had to do was ask for FRP to sign the blanket indemnity agreement.
I just don't know how your reading makes any sense for such a broad provision to only be triggered by work that you yourself do, when you are bound to do all of the work, regardless of who you subcontract or not.
Your Honor, when it comes to indemnity agreements, they're strictly enforced according to the terms, and they're enforced against the drafter, which in this case is Structure Tone. And if you compare it to the blanket indemnity agreement, that specifically says the performance of any work under the agreement, including work by the subcontractor or any of the subcontractors. So if they included it to be as broad as they're claiming, that's all they had to do was have us do that. And it's because they have a provision that doesn't include that language that we know that FRP never agreed to cover work that it didn't perform or that wasn't performed on its behalf. There's no...
Including by his own subcontractors?
Yes. This is very specific language it's active language, not passive.
Okay, thank you, counsel. Zubiaga.
Good afternoon, Your Honors. May it please the Court, my name is Ernest Bonacore on behalf of the appellant, Francisco Zubiaga. Your Honors, as we all know, the law favors a determination on merits. It is respectfully requested that this Court grant leave and permit an appeal of the lower court's first decision.
Counsel, I understand that, and I certainly, respect that. And of course, courts are also supposed to be able to sort of control their own calendars. But let me ask you a question. You could have, once the judge issued this order, instead of what you did, you could have made a motion to vacate the default judgment. I know your opposition papers had been submitted, I believe, prior to the time the judge wrote that first December 2019 order.
Yes, Judge.
But the judge said, I'm not going to accept your third stipulation, so I'm not going to deal with your papers, even though they had been submitted. Couldn't you have made a motion to vacate that judgment?
Certainly, Judge, that remedy was available to the plaintiff. In hindsight, that may have been the better route. But in this particular case, the lower court was in error. The parties here stipulated, albeit 3 times, but they did stipulate to adjourn.
Let's assume that we all agree that it was in error or it was an abuse of discretion. The problem is, it was basically the court declined to deal with your, as Justice Catlett mentioned, with that third stipulation. So that makes it not on the merits. It makes it non-appealable paper. So you need to make the motion before we will have to change this court's precedent in order to get to the merits.
No, Judge, respectfully, this court's precedent and the CPLR allows this court to review motions not made on notice, such as the lower court's first December 2019 order. And respectfully to the lower court, that was done in error. The lower court didn't even follow.
Counsel?
Yes,
But it
Your Honor.
wasn't made on note. I'm sorry, I didn't hear you. It wasn't made on notice, right? So
Yes, Judge, that motion was not, it was a surprise to the plaintiff because the plaintiff had already submitted 2 stipulations and the lower court did not even follow its own procedure. The second stipulation.
But isn't that why, if it's not made on order, CPLR 5701A2, isn't that the underlying reason why you need to go back to the court and say, Your Honor, you blew it. You didn't consider this or whatever, and then appeal from that denial.
But Your Honor, this court does have a vehicle pursuant to 5701C to permit this appeal in the interest of justice, and that's typically done on a routine basis. Doesn't have to be important. Certainly this matter is important to Mr. Zubiaga, but in the interest of justice, the lower court got it wrong. It's apparent that my papers were submitted in the time that I stipulated with the defense counsel. The lower court, without warning, disregarded them and made a decision and didn't even address the merits of the case and got the underlying facts wrong.
When you submitted the first 2 stipulations to the court, did you just submit the stipulation to the court? Did it need to be so ordered? Did it have to be made by motion?
No, Judge, it did not. In Bronx Motion Support Office, once assigned, this was not an adjournment that was objected to by counsel.
Oh, I know
Then
there was
would have
a
had to go into the court.
stipulation. I get it.
I would have had to requested that the court adjourn it. But in essence, in my opinion, the court interfered with an agreement between counsel that we've charted their own course and that the parties agreed to this time, albeit 3 times, and the stipulation was merely submitted in NICEF as per the motion support rules.
But you agree the court has the discretion not to accept it, particularly if there is no good cause for a continued adjournment. This was a 3rd adjournment, right?
I don't necessarily agree, Judge, that the court has the authority to reject a stipulation between parties. Again, the Court of Appeals has said that it's appropriate for the court to remain out of stipulations between the various parties.
Counsel, is it your position that the court had no discretion to control its own calendar?
Of course, Your Honor, the court has discretion, but without warning, and it wasn't even consistent.
But then when you get the order on default, why don't you go back and move to vacate?
Your Honor, I followed a notice of appeal, which I thought was the appropriate vehicle.
But you know from our case law that it's not, that you cannot take an appeal from an order issued on default, correct?
You cannot, that is correct, Judge. That's 50, that's the later, the second.
So you should have gone back and moved to vacate, right?
But, Your Honor, my papers had been in, and.
No, but I mean, at this point, you know what the deal is. So now there's no surprise. It may have been surprise when the stip was rejected. But at this point, you know that you've got a decision on default. And it's pretty clear what you're supposed to do, but you didn't move to vacate it, right?
Your Honor, then I thought that I'd be dealing with the lower court who was not amenable to even reading my papers from the get-go. And so my best estimate and my best practice, I thought, was to file the notice of appeal and to appeal these decisions.
But you know that once the court did not accept the stipulation, right? So forget about the December 2019 order. The court subsequently issued an order, a decision on the summary judgment motion, right?
Yes, Judge.
That was done on default.
It was marked on default, Judge, but
Right.
but I had already submitted my papers, and the judge, the lower court judge went through the facts of the case, and he cited a legal analysis. It's not it wasn't a one-line decision that's saying a motion unopposed granted.
Can I ask you one other question? I know your time is expired, but I'm looking at the two orders, one dated November 15, 2019, and the second one dated March 9th, 2020.
Yes.
And it seems to me that these are decisions made on the same motion sequence numbers. Is that right? They both say motion sequence number 1 and 2.
Yes,
So the first one was really made on this, it says motion sequence 1 and 2 for stipulation to adjourn.
yes, there was no motion to adjourn. I wasn't requesting the
So
court
he
to
was
adjourn.
just sort of writing a sort of a sua sponte decision on, I'm not accepting your stipulation.
Yes, Judge. The lower court treated the stipulation as a motion to adjourn, and there really was no motion. It was on consent.
Okay.
Okay, thank you, counsel.
May it please the court, Henry Masha of Rifkin Radler, attorney for the defendant, Finley Teller Housing. The court must dismiss both appeals from the December 2019 order and from the March 2020 order. The plaintiff lacks an appeal as of right from the December 2019 order because it was issued sua sponte.
What about the 5701C argument made by counsel? This court has the power to entertain it in the interest of justice, correct?
In theory, you could, but you shouldn't do that, and I'll tell you why. Even if you were to do that, you'd just be reviewing the December 2019 order, which marked the motion for summary judgment fully submitted, and that was the right decision because the part rules say that an affidavit of good cause is necessary, and the plaintiff didn't submit that.
But what about on the first and second stipulation? The judge did accept it without the affidavit, right?
That's true.
So, I mean, if I was an attorney, you might say, oh, well, I'll give a third stipulation. I probably don't have to give an affidavit. The first two went through. It was a change. It was sort of unanticipated. I mean, I dare say your office was somewhat surprised about that, too, because you were big courteous enough to sign off on the stipulation.
We were,
of
and we
adjournment.
would not deny that professional courtesy to an adversary. But the fact of the matter is the order was issued sua sponte, and the court has the authority to control its own docket.
You're
That's important.
not suggesting that counsel needed to include demonstrate good cause when in fact you already have a stipulation agreeing to the third adjournment.
Well, the part rules say that if there's an adjournment that goes past 60 days from the original return date, you have to provide a justification. That's what the part rules say. And that didn't happen here.
Again, as I said, the course of conduct, for lack of, no, for the first and second step was that it was okay without the affidavit. Then on the third step, the judge said, well, this is too much for me, and you pushed it a little too far, but not you.
Right.
So,
But,
and counsel,
again-
this was 150 days, right, by the third
Correct.
strip?
It was 150
What's that?
days, which,
6, 7 months?
right. And the opposition that was submitted did not even include any new evidence. It was all the same evidence that we had submitted on our summary judgment motion. So Supreme Court, while had the discretion to accept those papers or not, so even if you were to accept and review the December 2019 order, you would affirm it.
Okay, thank you,
you.
counsel. Okay,
Your Honor brings up an excellent point. Pursuant to the part rules, the second stipulation, technically, would have needed an affidavit. The lower court didn't reject the second stipulation, which in my practice only confirmed my idea that the parties stipulated to it. Therefore, it's not for the court to interfere and not accept the
the problem is, you keep calling it interference, but the problem is that the court has a responsibility to manage its calendar. So just because lawyers decide, oh no, we're gonna adjourn it 100 times, doesn't mean that the judge, sometimes they'll give you a break the first, second, third time, but there are limitations on the court's, not only patience, but the court's ability to adjudicate cases in his part.
Your Honor, that is true. A warning to the plaintiff would have been appreciated, and I would have gotten my papers in right away. As it was, I got them in before the time that was agreed upon by counsel. Thank you, Your Honors.
Okay, thank you both.
Read the rules carefully next time in Bronx Supreme, okay? Thank you.
Tioso, I believe appellant wishes to argue.
Yes, Your Honor. May it please the court, James Felix for the plaintiff appellant, Laura Tioso. I will keep it as short as I can, and would like to start off by saying that all we are seeking in this appeal is solely to reverse the denial of the plaintiff's motion for summary judgment on 3 out of the 6 causes of action.
So
Counsel, yeah.
it's your,
Go ahead, I'm sorry.
it's your, I'm sorry, it's difficult sometimes for us to hear each other. It's your position that the judgment of divorce gave your client 100% equitable interest in this condo, even though no deed had been filed because they didn't want to mess up the mortgage that they had in place. Is that correct?
That's correct, Your Honor.
Was there any equivocal language in your judgment of divorce that might lead one to say, well, maybe you're not really, don't really have 100% equitable interest or not?
Judge, the answer is no, and in fact, the opposite. And in fact, when reading the lower
Counsel, can I
court's
interrupt you? I'm sorry. So if the husband did not execute a quitclaim deed, then he was still on the deed, correct?
Correct, and he's still on the legal title.
Right. So what if, like, someone had a personal injury in the apartment? Could they sue the wife and the husband, or only the wife because she's, you're saying, the only owner?
Well, the fact is that she's 100% equitable owner.
So what's the answer to my
moment
question, then,
the judgment
counsel?
is filed in 2014.
Counsel, would he be exposed to suit as well, or if he had not executed a quitclaim in a personal injury lawsuit? Just yes or no?
He would be record owner, and I would say, Your Honor, perhaps he would be.
Okay. Now, what if the city, for some reason, executed eminent domain over the apartment for some strange reason? Would he be entitled, the husband, to whatever proceeds came from the exercise of eminent domain from the city?
Absolutely not. The judgment, they settled this matter.
Counsel, let me
In
just
2000
ask you, did the judgment creditor take the position that the husband actually did own the property?
The judgment creditor hasn't taken that position.
Has not. It's
just
not.
filed a
seeking it,
judgment.
Right. And it's not saying that, as I understood its argument, is that the judgment creditor is not denying that the plaintiff owns the property, but they're saying for some reason they should have the ability to show unclean hands or some kind of equitable, because there was no quitclaiming.
So
Is that correct?
The party that raised the unclean hands was actually defendant Dejean, the husband, who did not even put in a brief. If you read the underlying decision, and I did, and I was very happy until I got to the end, but the court below, and I think at least the 2 out of the 3 questions, the court below specifically said that the Court of Appeals has explained that in the context of divorce, Tiozzo and Dejean's, quote, legal rights to specific marital property vested upon the judgment of the divorce, with the in-coat rights becoming actual ownership interest by virtue of the equitable distribution judgment.
Right, so that's my question to you. Did anyone take the position that he actually owned part of the property? Does he take that position?
No, he doesn't, Judge.
Did the judgment creditor take that position?
The answer is no.
Okay.
The Court of Appeals was asked to rule in 2019, to rule on the question of whether a judgment creditor.
You're talking about the Pangea
Pangea.
Capital. Yeah, we've read that.
Yeah, but in Pangea, the judgment itself had no equivocation concerning ownership. And what I think is different in this case is there was some equivocation of ownership.
Judge, if I
He
may,
never executed a quitclaim deed.
Judge, if I may, the fact about the quitclaim deed, the agreement is clear, and it states as follows, that the parties fully intended for Tiozzo, quote, to have sole legal title to the Jane Street property. That's in the separation agreement. What happens, and the cases like that have been cited in my brief, including Darling, are specific as to what happens when you have a distribution of property. In this case, the ex-husband got property worth millions of dollars, including the Amagansett property. He got that. We got the right to do the following: to stay in the condo, to have the equitable right, the intent to have the legal right, and specifically in the separation agreement, the only obligations, no rights that Dejean, the husband, had was to pay the mortgage. And in fact, if in fact the property was sold, he still had the obligation to pay the mortgage if it wasn't paid at that.
So I'm
Notwithstanding the fact that she owns 100% of it.
He owns 100%.
Okay.
And Lens Capital did not put in a brief on this appeal.
No, Lenz did.
The husband
The
did.
husband didn't. And
Okay.
any other questions, Your Honors?
No, I think we're good.
Thank you very
We're good, thank you. People versus Catlett?
Good afternoon. Simon Greenberg for Appellant Denzel Catlett. Under People v. Rudolph, the court must vacate the sentence and remand for resentencing with a youthful offender adjudication.
I mean, the
on
people
record.
concede that, right?
Well, they concede that he was eligible for youthful offender status, that there was no determination made on the record at sentencing, And they also concede that because the appeal was actually pending when Rudolph was decided, that Rudolph applies to this case.
So they agree about retroactivity, by.
They do agree about retroactivity, yes, Your Honor. So that's
what's
really,
the controversy?
that is all three elements, really, so to speak, of a Rudolph claim. Eligibility, failure to comply with Rudolph, and that Rudolph applies. The only thing the court can do now is remand for resentencing. That's the obvious and correct outcome of this appeal.
Okay.
If your honors, if you don't have any additional questions, I would respectfully request to reserve the remainder of my time for rebuttal.
Okay,
Okay,
sounds good.
thank you.
So you agree that Rudolph requires a YO determination, right?
May it please the court, and we agree, just to clear up the record here, we agree that Rudolph is precedent. We agree that defendant would be eligible because he committed and was convicted of manslaughter, and we also agree as to retroactivity. In our brief, we, however, argue that Rudolph is distinguishable because in this case, unlike in Rudolph, there was no discussion at all about youthful offender eligibility. There was no determination on the record.
Is
Here-
there a requirement that there be a discussion about YO? I mean, the court knew the age of the defendant.
So, Justice Acosta, Rudolph says that even if youthful offender is not even requested by defendant, the court has to make an independent determination as to YO eligibility, and that determination has to be on the record. We have that here. In fact, in defendant CPL 440,
Well, you have some you don't have an adjudication, you have an actual discussion by the court or colloquy by the court about how he felt, about the nature of the crime that had been committed, etc. I mean, I agree this was horrible, but somehow that's not sufficient. That's not an adjudication, right?
Your Honor, we have more than that. Specifically, we have a decision by Justice Farber, the same judge who presided at defendant sentencing, unequivocally denying what youthful offender for this defendant. He says because an innocent person was murdered, an innocent bystander was murdered, youthful offender is off the table. And he, in fact, says if counsel had even asked for youthful offender adjudication, that would have been counterproductive. So our main argument, Your Honor, our first argument is dismissal. And if you allow me to briefly just address the dismissal, anticipating defense will come back and discuss it, I would first submit to this court that dismissal is warranted here because defendant failed to prosecute his appeal. And just to touch on 3 points there.
Counsel, wait a second. Let me just ask you, how do you distinguish then People versus Gutierrez and other cases that say, sure, a discussion on the record like there's no way I would ever do that is not sufficient. You need an explicit determination.
Your Honor, I completely understand Gutierrez, People versus Ely, which we cite. However, the distinction is this. In those cases, this court looked at, there might be inclinations, there might be discussions, mentions on the record, indicating that the judge would not grant YO. But we need a determination. Here, we have a decision. We have justice.
Can you point where in the record? Because I see the judge saying, that no prosecutor or judge will consider giving youthful offender treatment, et cetera, but I don't see a hereby,
Your Honor, in the decision, on page 3 of Justice Farber's CPL 440-10 decision, page 3, Justice Farber says, youthful offender sentence would not be imposed for the murder of an innocent bystander. For counsel to have even suggested this disposition would have been counterproductive. That is an unequivocal, independent determination that the court made as to defendant's eligibility and finding he was not deserving of YO treatment. Returning briefly to the dismissal point, 3 points. One, there is precedent for raising a failure to prosecute argument in a respondent's brief. In People versus Catlett at the Appellate Division, the people moved for dismissal for failure to prosecute. This court denied that motion with leave to the people to raise that issue in the respondent's brief. Defendant then issued their reply responding to the delay, explaining the delay, and the defendant attached an affidavit explaining the delay. Defendant says he needs an opportunity to file an affidavit. He had one. He could have responded in our reply, explaining the delay and attaching an affidavit, moving to enlarge the record and attaching an affidavit, explaining his delay. He did not. And finally, Your Honor, as to people's service of our respondent's brief, that is not an issue.
Counsel, did you ever make a motion to dismiss the appeal?
We did not, Your Honor, and we're not.
Doesn't the statute require a motion?
No, Your Honor, respectfully, it does not. CPL 470.60 subdivision 1 entitles this court and authorizes this court with independent authority to sua sponte dismiss without us.
Saying on our motion.
Yes, Your Honor, and that's what the people are requesting here, and it's perfectly proper under precedent People versus Catlett for us to make that argument in our respondent's brief. Just quickly responding to the service, the provisions defendant cites there are only relevant when appellate counsel has not yet been appointed. Here, appellate counsel has been appointed. And defendant's excessive sentence point, assuming this will come up on rebuttal, is foreclosed by the valid appeal waiver in this case. Even if this court finds that waiver valid, this was an intentional shooting, an innocent bystander, Quilvio Pimentel, was killed, and defendant's sentence was an appropriate exercise of discretion. The people asked this court to affirm the judgment.
Thank you.
Thank you.
I'll give you an extra minute.
Okay, thank you, Your Honor. With respect to the dismissal issue, the statute is clear that a motion by either the respondent or the court is necessary. The people never made a motion here, and the court also hasn't made a motion, a motion would consist of, we expect it, if the court were to do that, it would consist of an order to show cause. Nothing like that has ever been issued in this case. So this is not a proper procedural posture under the statute for the court to dismiss the appeal.
Counsel, can you address the district attorney's argument that there was an explicit determination on the record as to YO's status?
Yes, Your Honor. There was not an explicit determination as to YO's status.
Well, the judge said, even if you had asked for it, in this situation, youthful offender determination is off the table. Isn't that mean no? You don't get it?
But the determination has to be made at sentencing, and that was, first of all, that wasn't a full-throated determination. It was resolving an ineffective assistance claim raised.
And it has to be made whether or not it is a waste of judicial resources, as the people suggest.
That's correct, Your Honor. This court always remands for what in some cases is almost a pro forma proceeding if there is not an explicit determination on the record.
Okay.
So, and here, I would, as we said in our brief, I would add that saying in deciding a pro se 440 motion that you would not have, that a judge would not have granted youthful offender status is not an adequate substitute for doing that at sentencing. My client was pro se in that 440 motion. He did not have counsel appointed. He never appeared in court. He did all of that 440 writing from prison. That's not a resentencing. That's not what Rudolph calls for. We understand the judge's position, but we understand why the judge wrote what the judge wrote in the 440 decision, but that's not a resentencing proceeding.
Okay. Thank you.
Thank you, Your Honor.
Thank you both.
Your Honor, there's two appellants. I represent the respondent. I'm happy to sit in the back.
Who wants to argue first?
I'm happy to argue first, Your Honor.
Well, the M investment appellant will go first, right?
That's me, Your Honor.
Okay, so, I mean, usually I don't get in the middle of who sits where, so you guys figure it out. Who's gonna go next? Maybe that's the,
I'm happy to sit in the back.
okay, that's fine then.
Judge, I think I should sit in the back only because I oppose both their situations.
Knock yourself out. As long as you stay 5 feet apart, you're good. The CDC guidelines are usually not part of the court's,
You didn't check up on them before you got out here today?
I'll measure their 5 minutes.
Good afternoon, Your Honors. Harlan Levy for Mark Schwarzberg and M Investment. There are 3 points that I plan to cover this afternoon with my 6 minutes. First, the court below relied heavily on 1 page of a document that appears on its face to have been altered, with insertion of a purported asset list, reflecting at once Yefimsev's alteration of a document and also an inadequate asset list. Second, the trial court concluded...
Counsel, is it sufficient that the parties seem to know where those properties were located?
I haven't seen any indication of that.
Well, she
at
moved
all.
into one of the properties, didn't she? And she took a mortgage on another?
Excuse me?
Didn't the Ms. Dubrovsky move into one of the properties? Am I mistaken?
I don't have any knowledge of that, Your Honor. I know that there was a loan taken on one of the properties that produced a total allegedly of $1.3 million for
Right. Maybe she didn't move in, but on the $4 million apartment in Moscow, didn't she take title to it?
Well, there is an indication that she took title to that apartment, yes, but that's not what the contract specified. It didn't specify a $4 million contract in Moscow. It specified 2 apartments in Moscow. And so the issue here is whether the asset list itself created the requisite specificity.
Well, it says one is $4 million and one is $2 million in the Moscow apartments. Not the most specific appellation, true, but I thought that there was at least 2 apartments were identified by the amount of money that they're supposedly worth.
Well, the way that the contract was structured was that the assets that were provided were supposed to total $19.8 million.
Right.
Never even came anywhere close to that. And there was, and to the extent that there was a finding of partial performance here or substantial performance here, I think it was partial performance, but to the extent that there was a finding along those lines, that's especially here where there's an indication of a total having been received of $5.3 million on a $19 million commitment. When you consider that in the context that the case law provides, that the question of whether there has been satisfactory partial performance is an issue of fact for trial. It's not something for a judge to decide on a motion to dismiss. The case law is clear on that, just as the case law is clear on the question of whether there being an agreement to agree is a question to be decided as an issue at trial rather than on a motion.
Right, your position is essentially the trial court took as a premise the validity of the FGP contract.
It did. It did take it as a premise. It adjudicated an issue on a motion to dismiss, sponsored by Yefimsev, a convicted felon, and a document that, as I started with, Judge Moulton, a document that on its face was inadequate and appeared to be altered. I could actually...
So you want to keep your first counterclaim in the case. That's what the judge dismissed below, correct?
The court dismissed Schwarzberg's and M Investments' entire first counterclaim.
Right.
That entire
first counterclaim.
And this was a claim.
Well, mostly, Mr. Levy, mostly because the court said that, or thought that you lack standing to challenge the enforceability of that assignment agreement, right?
The court found that there was no standing to challenge the agreement, Judge Acosta, but the premise of finding that there was no standing was that the deal was a good deal, and that it was a contract, that it was a binding contract. So they said that we've decided there's a binding contract on a motion to dismiss.
Right.
They didn't have an ability to decide that there was a binding contract.
Got you.
Because
So they threw out.
your claim is that there was no valid contract, and isn't plaintiff's claim sort of the flip side, that the other contract wasn't binding? I mean, everybody's questioning what contract is really the binding contract, and how to proceed, and who has what percentages.
Well, that's part of the issue. There are competing claims
Right.
to this interest in an LLC.
So it should be back in so that you can litigate this issue to figure out which contract and who's got what. That's really what this case is all about. It shouldn't be decided at this stage of the
That's
litigation.
right, especially with findings of fact having been made, a whole array
But counsel, this
of findings of fact
I
made.
mean, we often are charged in the first instance to say, is this an agreement to agree or a contract with sufficient terms? That's not inappropriate for a trial judge to do on a motion to dismiss. I myself did it many, many times to decide, is this a full and complete contract, or is it a letter of intent, a letter, or some other agreement to agree? You're arguing as a matter of law that the judge could not decide that this was a full and complete contract?
I am arguing first and foremost that it was not a complete contract.
Okay.
That's the first.
Not that she didn't
that's
have the
that's the
ability
first
to
point,
choose
that there was,
it. She
that there
just,
was,
you still think that she made the wrong decision on it.
that there was, if I may just finish.
I'll give you an extra minute.
Thank
Go
you.
ahead.
That there were a number of documents that were credited that should not have been credited on a motion to dismiss, that there was a finding above all relating on literally one insert on a page, and it's page A176. And if you look further beyond the work that you've already, I'm sure, done, and looking at the appendix, if you look further at A176, you will see that that's the page that the court relied on, that there is a sentence providing the supposed consideration that appears to be inserted in an altered text and an altered font, and that on its face appears to be altered. And this in a case, again, where this is, where Mr. Yefintsev has been convicted in Russia of forgery as part of a massive multi-million-dollar business fraud.
Okay, thank you, Mr. Levy.
Thank you. Thank you, Judge.
Let me hear from Cross Appellant Pirogova.
Good afternoon, Your Honor. May it please the court, my name is Victor Worms, and I'm the attorney for the cross appellant, Ms. Natalia Pirogova, Your Honor. There is no dispute here that the M investment agreement is invalid, or that the FGP agreement is also invalid, Judge. It doesn't comply with the Madison 33 Partners amended operating agreement. That is beyond dispute. More importantly and directly, it also didn't comply with the Deutsche Bank loan agreement, which specifically provides that where there is a transfer of 20% or more, there has to be notice sent to the bank by the borrower, which in this case is Madison 33 owners, and they have to approve that transfer. The transfer has to be made and sent in 15 days ahead of the proposed transaction.
We're familiar with that provision, counsel, but do you want to talk about whether your appeal was properly perfected first, or you want to touch on
In
that?
what respect, Your Honor, in terms of standing or in terms because the appeal itself is perfected. The only question before...
But it wasn't perfected timely, I guess, is the
Oh,
question.
it was actually. It was perfected. We made a motion, Your Honor, and there was a stipulation that was entered in by all the parties that extended and consented to the court, granted an enlargement of time. A motion was made and was actually granted by this very court that allowed us to have the extension of time. The issue on the perfection, Your Honor, was not that it wasn't done in time, was that it wasn't done in time because there was a confusion as to when our time was supposed to be. But once we recognized that, and Mr. Levy and Mr. O'Donnell will confirm to the court that we did have a written stipulation, we made an actual motion, this court issued a decision that allowed us to file our appeal. So it is timely. There is no issue of appellate jurisdiction, Your Honor.
Counsel, when you did that, we granted your motion to extend to the June term, correct?
Correct.
And so under that stipulation, when will your papers due?
I called the appellate division's court's office and they told me it was due. I don't have the specific recollection, but I did file it timely, Your Honor. There was no issue of untimeliness because I called the court, I spoke to the clerk, the court specifically gave me a specific date by which it had to be filed, and I did file it on time, Your Honor. So I didn't see this as an issue, and it wasn't brought to my attention before because the clerk with whom I dealt with, Mr. Lopez, I believe his name is, he accepted my brief, he confirmed it was filed, and he never suggested otherwise because the timetable for that filing was based upon information given to me directly by the court, and I complied with it. So if there's an issue on that, Your Honor, it's the first time I'm hearing it. There is no issue with respect to the fact that the prior filing wasn't timely, but the stipulation was entered into by the parties. I then confirmed the deadline with the court. I specifically called because I wanted to make sure it was done on time, and it was...
Well, I mean, the day, it's set forth in the statute. It has, I mean, regardless what anybody
I understand,
said,
Judge, but...
There are days that are set forth in the rules of the court, and those are what
controls?
follow,
I
right?
understand that, Judge.
And
So
if your brief was filed late, then
then that's a problem, obviously, Judge. Okay. But as far as I'm aware, Judge, I believe that in my communication with the clerk's office, I was given specific deadline as to when, based upon the court's record, I was supposed to file it, and I believe that there is no issue on the timeliness. If I can address the merits of my appeal, Your Honor, I would do so unless the court has other issues on the appellate jurisdiction issue. But getting back to the issue...
Go ahead.
I'm sorry, Your Honor.
No, go ahead.
So the real issue before the court, really, is whether or not Paragova has standing to raise the question of the fact that both the M investment agreement and the FGP agreement did not comply with both the Madison 33 Partners operating agreement as well as the Deutsche Bank agreement. That really is at the core of what the court said as to why it denied our motion. And I believe...
What was the direct harm flowing from the contract that entitles you to standing to challenge the contract?
Ms. Paragova is the actual owner of the 40% membership interest that was purportedly sold by Mr. Dubrovsky without her consent. And therefore, if you have an ownership interest, a beneficial interest, which is undisputed, no one disputes that Ms. Paragova is the actual owner. So the question is, if someone sells something you own and does it without your direct involvement or consent, the alienation of your property interest is damage. And Mr. Dubrovsky, in the answer, repeatedly stated, time and again in that I am not the owner. Ms. Paragova is the owner.
Doesn't the harm have to flow directly from the contract itself, or you think that we're just making a distinction without a difference?
No. The question really is one of arm. How do you define that arm? And the question is, if you have your property interest alienated, if you are dispossessed of your property rights and your property itself, that itself is an inherent harm. I don't think we need
Counsel, who's the owner of the property? Aren't LLCs the owner of the property?
The property is owned by...
she doesn't own that property.
Not directly.
Right, exactly.
Right,
so she doesn't have a direct interest. I'm a shareholder of Mobile, And if Mobil sells a gas station, and I don't think it's proper, the fact that I own a share in Mobil doesn't make that direct harm to me.
It's not exactly an identical comparison, Your
I
Honor.
think it is exactly that.
And I'll
Well, she doesn't have 49% of Google. That's,
Well, I wish I did, right?
It's more than that. Ms. Dubrovsky has always maintained that she's not the owner of this interest. She doesn't have it. It's not hers. So she's selling something that she doesn't own. In your Mobil example, you actually own those shares. So it's a different circumstance. But here, it is an undisputed confirmation and acknowledgement that Ms. Dubrovsky doesn't own it. So the question is, if I sell something that I don't own, and someone else owns it, the person who owns it actually suffers a damage because of the alienation of their property rights and interests. And I think that provides the standing. If I may just address one.
I'll give you 30 seconds.
Thank you, Judge. And we get to the issue of the condition precedent notice. That is a very critical part of this case because the court below conflated mere notice with a condition type, a condition precedent notice. In the condition precedent type notice, you cannot simply, the court simply can't ignore it. Substantial compliance is not sufficient. It requires strict compliance. It is beyond dispute that the notice provision in the Deutsche Bank agreement was not complied with. The court below decided to just say, well, we're going to waive it, we're not going to consider it, it's the technicality. It is more than a technicality. It is a condition precedent to a valid transfer. So the fact that the notice was not complied with, was not followed, makes the transfer itself, both to M Investment and to FGP, invalid as a matter of fact.
Okay, thank you, Counsel. Okay, let me hear from Respondent.
May I proceed, Your Honors?
You may.
May it please the Court, Sean O'Donnell with Herrick Feinstein on behalf of the Respondent, FGP. Your Honor, let's talk first about standing. So Judge Schechter, in her very thorough, very well-reasoned decision, laid out the rules for standing, which are bedrock law here in the First Department. If you're not a party to a contract, you can't challenge that contract's validity.
But counsel, do we have to knock out the whole first counterclaim on that basis?
Yes, well, to the extent that it's, I'm fine, Your Honor, to the extent that it's amended, if it's only to the extent that it seeks to invalidate the FGP assignment agreement.
Well, I mean, it's kind of by implication, but what if they just stopped at paragraph 46, which reads as follows, verbatim, M Investment is the legal owner of 100% of the right, title, and interest in 172 Holding pursuant to the M Investment assignment agreement. Boom. Can you leave that counterclaim in?
Can you leave that in?
Yeah.
Well, we moved to dismiss that claim. So there's two things that are happening. And this goes to one of your questions before, Your Honor. So they actually moved to dismiss our counterclaim, our claim that our contract is valid. And at the same time, we moved to dismiss their claim that our contract is invalid. So there's two things that are happening. We're not
So
seeking...
how does one go out and one stay in?
Well, we did not seek a motion to dismiss to get rid of their contract. It's not like he said to you a minute ago about this flip-flop and it's just an evidentiary hearing. That's not the case at all. What was decided before Judge Schechter is whether or not the people who are not parties to the agreement, most importantly MIC, has standing to challenge the FGP agreement. And bedrock law in the First Department says if you're not a party to the agreement, you either have to be a third-party beneficiary or you have to have suffered direct harm.
Right.
Here, they don't allege to be a third-party beneficiary, nor could they, nor can they allege direct harm because, as stated in the documentary evidence and even in their own pleadings, they did not exist at the time of the FGP assignment agreement.
Except, counsel, they can defend your claim
Absolutely.
on the basis that your contract isn't bad.
100%.
So if the counterclaim has, if your claim, the counterclaim has more than just their allegations about the impropriety of your agreement or the invalidity of your agreement, has more than that, and they could defend anyway, what's the difference?
Oh, well, it's significant for a variety of reasons.
Because you're saying because of the burden of proof?
Well, one, from the burden of proof, but also, right now, this is a live agreement. There's a dispute as to how the condominium is being managed. As you know, cases go on for a long time. We haven't even had depositions here. Our ability to assert our right under the FGP agreement, which took place years ago, which we transferred millions of dollars to, which we've transferred property to, is being impacted by the fact that there's this litigation out here. So having a ruling today that the agreement is valid or that they can't contest it is extremely important. And it's really important to note who's missing
In what
here.
way? Because they're just going to assert a defense based on those same allegations. So I don't understand why it matters to you.
Because the defense is not to us owning an agreement, right? It matters to us because right now their claims impact our ability to effectuate our rights under the LLC agreement. So they're claiming that our agreement is invalid.
Right. And they're going to claim that on their defense. Their first affirmative defense is, your agreement is invalid, which they're perfectly entitled to do.
God bless. I completely
What is the
agree.
difference? I still don't see why that makes a difference.
Because their defense would be to a tortious interference with contract claim. Their defense.
No, to your first breach of contract claim. They're going to defend it on that ground.
I'm not suing them for breach of contract. They're not a party to the contract. The person who is a party to this contract is Louisa Dubrovsky. She's glaringly absent from this courtroom because she doesn't challenge the contract's validity, because she doesn't challenge the assignment. And the notion that my colleague has said to the court that the Judge Schechter's decision rests on a single page is so far from the truth and from her decision. If you could take a look. So he started first at the record at A176. Now what that shows is the FGP operating agreement that was amended to list the assets that were agreed within the time period under the assignment agreement. It's not only does it list the assets, but it's initialed by Ms. Dubrovsky on each page, including the page where the assets are listed. There's nothing nefarious about the fact that you took an operating agreement and you amended it to list the
Counsel, let me
assets.
just stop you a second. Are you not seeking a declaratory judgment, a declaration that your contract is valid?
Yes, and we're entitled to that.
You sued all defendants on that claim, correct?
Yes, we
So
asserted
all
against.
defendant has to do is assert a defense against your declaratory judgment claim saying, no, your contract isn't valid. And all of this machination doesn't make any difference. It's the same thing. That's what I'm unclear
I
about.
appreciate the decision, your question, Your Honor. I'm trying my best to answer it. It is meaningfully different. I understand that they still on their defense, and I agree, can assert as a defense whether or not this contract's valid. I don't think they're going to get very far for all of the reasons that are laid out in Judge Schechter's decision. But between now and trial, which is still light years away, there's a lot that goes on that impacts the property. May I please continue?
Yeah, you go ahead.
There's a lot that goes on that impacts the property, including the condominium development. There's additional capital raises. And right now, because folks like MIC, who have no right to challenge the validity of the agreement, are doing so, that's being held against us in terms of our ability to have our say as to how distribution should be made, financing onto the LLC agreement. So there's a real impact today, aside from the trial. We have to deal with their issues at trial. If I'm worth my salt as an attorney, I'll be able to do that because there's such a mountain of documents that shows that this was a valid agreement, that there were millions of dollars of cash and assets. And Judge Schechter appreciated that, which is why she has such a long decision which thoroughly lays out, and she didn't make up the law. The law in the First Department is you have to be a party to the agreement to challenge its standing. It doesn't say unless it doesn't matter or unless there's a defense. There's no carve-out that exists like that under the law, and this is a good example as to why that's the case.
But I don't understand, if the defense is the same as the counterclaim, how is that going to change your ability to get financing?
So their
That's
counterclaim...
going to look at the defense and say, uh-oh, there's a question as to the validity, so I'm still not satisfied that it makes any difference whatsoever.
So we're this close. As it relates to the counterclaim was dismissed. That's why we moved to dismiss their counterclaim. And Judge Schechter correctly dismissed it. So if the counterclaim, limited to the extent that they're seeking to invalidate our contract, is dismissed, and if their attempt to dismiss our claim that it's valid is that if that denial is upheld, if those two things that Justice Schechter ruled, that has an impact today. We still have to we still have to deal with the trial, and I'm frankly pretty confident about that. But the ability to deal with this issue today is precisely why the motion to dismiss was made and why Judge Schechter ruled in our favor. We spent a lot of time on this. I want to answer.
May I ask one question? What's your position on the timeliness of the Paragova appeal?
Okay, so as it relates to the Paragova appeal, there was a stipulation, there was an extension that was granted. That extension came and went. They missed it again. And what Paragova actually did was file at the time that the respondent's brief was due, as opposed to when the appellant's brief was due. So they failed to perfect it on a timely basis. But even if the perfection was done in a timely manner, the argument that they make, it's one argument, it's a notice argument. They claim that the notice to Deutsche Bank was defective because their agent, Dubrovsky, their alleged agent, sent it instead of the company. And there are two problems with that. You heard a minute ago, he said the notice is required whenever there is 20% more of an interest that's been transferred. It's in the record, it's at 258. It's a 19.6% interest that's being transferred. So the notice wasn't required. And even if the notice were required, think about what you'd have here. You'd have defective notice that was created by their agent with no prejudice alleged by Deutsche Bank or the company, and that they could somehow use that to undo an agreement after millions of dollars of cash were transferred. That's why the First Department law is it doesn't require strict compliance with the notice requirement unless there's been prejudice and an absence of actual notice. Here, the agent gave the notice, and they certainly can't have been prejudiced by it.
Okay, thank you.
Thank you, Your Honors.
Mr. Levy?
Your Honors, two significant points. First, with regard to this bedrock law comment, there are cases which do allow challenges to contracts where a claimant is neither a party to the contract nor a third-party beneficiary. We point to Lumberman in our brief. We point to Reliant and Lumberman in our brief. The cases that counsel is relying on are quirky cases. Decolator was a case reflecting no actual injury and instead a claim based on ethics violations. Arrow was a case by a contractor claiming that it could challenge government requirements in contracts which didn't allow it to get contracts because its products didn't comply. None of them are cases where you have two. My client is a business person. I don't know exactly who his client is, but none of us do. But two people competing for an ownership in an LLC and alleging ownership. Counsel was asked whether my client would be able to defend these cases in the light of Justice Schechter's decision. He said, absolutely. Well, guess what? He's moved for summary judgment against my client in the Supreme Court based on Justice Schechter's decision. So I see a certain inconsistency here. And I want to make it clear, my client is seeking a declaration that he owns the property. He needs to be able to defend, and he also needs a declaration that he owns the party.
But isn't that what the lower court claimed? I mean, the lower court said basically that there's no harm to you flowing from the contract, that the harm that you suffer was harm because Dubrovsky sold to you what it already knew was the subject of the earlier assignment agreement.
But
what do you say to that?
I say two things to that. First, there was no sale, and the harm is that my client believes that he contracted to buy the property. And second, there also were pleadings in my client's complaint that were relevant to this issue. My client says that he talked with counsel's client about this transaction. It's in the pleadings, and that Yefimsev said, I can't afford to complete the transaction, and I'm not going to complete the transaction. And you know what? Assuming the principle that a person also gets the benefit of inferences from his pleadings, I expect that there will be testimony at trial that there were facts that supported my client's view, facts including telephone calls made with Mr. Yefimsev and Mr. Yefimsev abandoning any interest in saying, you can go on.
So counsel, let me just, assuming for the moment that the reason why there's a motion for summary judgment is because of that part of the decision that says that even if you had an interest, this is a completed contract, right? That could be why there's a motion for summary judgment, and not having nothing to do with whether or not, I mean, your client wasn't even around when that contract was signed, correct?
My client, Mark
So I don't know
Schwartzberg,
how you could have any harm from a contract when your client didn't even exist when the contract was entered into.
Judge Scarpula, my client, I have two clients. I have M Investment, which was an entity that was formed by Mark Schwartzberg. Mark Schwartzberg was around. Mark Schwartzberg was actually the manager of the property.
But that's
for a
not who
period.
the contract is with. Your
But-
contract is not with that party.
My contract was not around, you said?
No, your contract is not on behalf of that party. The contract that you're trying to seek as valid is not on behalf of that party.
The contract that,
Who is your contracting party that you are seeking a declaration that this party owns the property?
it was Dubrovsky.
And I think you're saying the subsequent sale to your client was the good sale, correct?
I am saying that it is the good sale that was, that there was
now
notice.
who is the party to that subsequent sale?
I believe it was Dubrovsky. I would have to double check to see if it was perhaps Pirogova, but it was one of those parties.
And your client?
And my client.
And who is your client?
My clients are M
No, I'm
Investment.
talking about on that contract.
On that contract, my client is Mark Schwartzberg and M Investment, who it was sold to.
And that client was not around when the first contract, that group was formed to execute this deal, correct?
That's correct.
So
Yes.
they wasn't around when the first contract was signed, correct?
Yes, but the first contract was essentially abandoned. And then,
Well, I'm not disputing anything else. We're talking about this narrow issue of harm to you. That's all.
the harm is a cloud over the title of a property that Mr. Schwartzberg and M Investment believe that they have purchased. That's the harm.
Okay, thank you, Mr. Lee.
Could I just make just,
I'll give you 30 seconds.
I'll stop there, Your Honor. Thank you very much.
Okay.
Thank you.
Let me hear from the cross appellant, Pirogova.
Thank you very much, Your Honor. Just to confirm and sort of reaffirm what was said by me earlier, Your Honor, is that there is no dispute that the timetable, the notice provision in the Deutsche Bank wasn't complied with. Counsel for FGP mentions that his percentage interest was less than 20%, which is correct. What he doesn't mention, however, is that the Deutsche Bank agreement requires that the borrower in this case, which is Madison 33, must be the party that sends in the notice, not some third party or some person who is unrelated to the Deutsche Bank agreement. It is extremely specific. It is undisputed that they did not send that notice in as provided for in the Deutsche Bank agreement. In fact, with respect to an investment, paragraph 8 of their assignment agreement makes clear that they understood that the assignment's validity was dependent upon this notice provision, which they didn't comply with. In actual fact, they sent their notice in before, they didn't send a notice in, Judge. The transaction became effective before the 15-day notice period that was required. So it is undisputed as to them that they didn't comply with it. There is no doubt on that. With respect to FGP, they also didn't comply with it because the agreement specifically says that the borrower must be the person that sends the notice in. The borrower is a defined term in the Deutsche Bank agreement, and it specifically says the borrower is Madison 33 owners. So with respect to both sides, Judge, no one disputes, no one can dispute that they failed to comply with the notice provision. And in fact, the Madison 33 partners amended agreement says if you fail to comply with the Deutsche Bank agreement, any assignment is invalid. So the only issue they can really argue to the court is whether we have standing. If this court determines that Pirogova has standing, then both agreements become invalid because they undisputedly did not comply with both the Madison 33 Partners amended and restated agreement and with the Deutsche Bank agreement. That is beyond dispute.
Thank you, counsel. Thank you all. Three 22 West. Let's take a 30-second break. Let's try to get this one done quickly.
Okay.
Okay. We wanted to take time, but not as much time as this litigation has taken.
That makes sense. May I proceed, Your Honors?
You may.
Okay, good afternoon. Andrew Darcy from Mobilization for Justice on behalf of the appellant, Lawrence Guarino. Your Honors, there are 4 key points that I would like to convey to you today. This long litigation notwithstanding, at its core, this case is simply a summary holdover proceeding. And Mr. Guarino is simply seeking to avoid his eviction from his home of nearly 30 years. He has a proprietary lease that is signed by 2 board members of the HDFC that grant him both ownership and possessory rights.
But there were allegations in this massive record here that those 2 people really did not have the authority to sign the proprietary lease, and that he knew, Mr. Guarino, your client, knew that and was sort of working in cahoots with them. Isn't that a claim that I saw, that I read?
Well, there are various, allegations out there about, again, conspiracies and cahoots and whatnot, but the record is pretty clear here. In 2009, there is no dispute that the two board members that signed that proprietary lease, Ms. Benavides and Ms. Ho, were shareholders in good standing. It was not until the derivative action between them and the president of the board ended in 2013 that they were prospectively removed from the board. And by the way, they are back on the board now. They have been since 2017. And so we think there is no doubt that they had actual authority to enter into that proprietary lease. We also believe that to the extent there is any dispute as to that, there is no dispute they had apparent authority. Ms. Benavides and Ms. Ho were board members from 1992 up until 2013. Mr. Guarino moved into the premises since 1993.
So those two individuals had the authority to act, and they did act.
That's correct, Your Honor. And this leads to another key point, though, I think that goes to the second point I wanted to make here, which has to do with this argument that we're having about their authority to act was litigated in the derivative action. I mean, that was, for lack of a better term, a war between two factions of the board. And they lost that case, no doubt, but we can't keep coming back to issues that transpired before that case ended. Again, the HDFC asked Judge James to nullify any contract that Ms. Benavides and Ms. Ho had entered into with third parties like Mr. Guarino. They litigated that counterclaim through trial, and at the end of trial, Judge James denied them any relief on that. Okay, and I don't think there's any ambiguity in her decision. But even if there was, it's not for the HDFC to come before this court to effectively ask it to sit in appellate review of what Judge James did. It was to seek modification or clarification or an appeal from that case. Moreover, the first time that they effectively pled anything relating to their validity to contract in this case was in 2018. That is 9 years after the proprietary lease was signed and 3 years too late for statute of limitations purposes. So we don't think that they get the chance to relitigate the validity, the authority of Ms. Benavides.
Is that the case, counsel, even if, as they allege, that the bylaws were not complied with respect to the transaction? So they say that the sale was not approved by 2/3 of the directors and ratified by the shareholders. Is that waived, if not timely raised? Is that what you're saying?
I do think so, Your Honor, and I guess I have two points in response. One is many of the allegations simply aren't true. I mean, Ms. Benavides and Ms. Ho, again, called a board meeting. They voted. We have affidavits from them. They voted to go forward with the sale, and they both signed the proprietary lease and have put in affidavits, attesting to that fact. And again, I think that we should win on our counterclaim regarding a declaratory judgment. But one of the first points I did want to make is going back to the first thing I mentioned, which is that even if there are questions of fact relating to the validity of this proprietary lease, coming back to the point that this is a holdover case, and in this holdover petition, the proprietary lease is not mentioned. It is alleged that Mr. Guarino was a quote-unquote former tenant, and it's alleged that he failed to exercise his options to purchase the shares. Those allegations are incomplete and demonstrably false. So if nothing else, we think the holdover petition should be dismissed because it doesn't comply with RPAPL 741-2, which requires a petitioner to plead.
I thought that there was an acknowledgement that at least the lease on which he acquired the proprietary lease the process was not completed because he was in essence asked for a bribe.
I'm sorry, in essence, he was?
In essence, asked for money to be given to the board member on the side. So I thought you acknowledged that process was not completed, granting him shareholder rights.
And not exactly, Your Honor. So what happened was in 1993, when Mr. Guarino entered into, and if I may.
Yeah, go ahead.
When he entered into possession of the premises, he had a probationary lease. There is no dispute that he passed probation. There was no dispute that he was offered the shares in writing. There's no dispute that he signed a written acknowledgement saying he wanted to go forward with the closing within the relevant time period. And at that point, based on what my client and the two board members who are still in the building who were there then attest to, is that the then president basically was running this HDFC, maybe for lack of a better phrase, like a criminal organization. He was demanding bribes under the table. He was putting friends and family in. The closing did not go forward at that point. We do think that the lower court was wrong to dismiss the counterclaims and defenses relating back to that time period because it's in essence, it's unfair to allow the HDFC to make allegations that he never exercised his right to purchase when we believe he did. But in any event, Miss Benavides and Miss Ho, throughout that time period when they were trying to get the building back in shape, told him, we will go forward with your closing. Don't worry about it. He invested $50,000 to renovate the premises, which is why I think we have a valid promissory estoppel.
But you agree that that requires credibility assessments with respect to, I know that there were affidavits submitted. That's something to be argued before the trier of fact, whether it's a jury or a bench.
Well, and eventually they did sign the proprietary lease, so I don't think there is any dispute that 2 board members signed a proprietary lease with Mr. Guarino. I also don't think you have any dispute that in 1993 and 1994, you have sufficient writings to establish a contract. You identify the apartment, you identify the purchase price, and as the lower court found, Mr. Guarino established that there was an offer, that he accepted, and that there was an intent to be bound. Those counterclaims and defenses were dismissed based on the statute of limitations, but respectfully, I think Judge Cohen got it wrong because he didn't apply CPLR 203D or 205B to those counterclaims and defenses from the early 1990s. And effectively, what those 2 provisions state is that if they're going to make allegations about how Mr. Guarino entered into the subject premises, again, saying that he never exercised his right to purchase the shares and is a former tenant, and in the ejectment action, they pled that he never even signed a written lease, those allegations are simply false. It would be unfair to not permit Mr. Guarino to respond with defenses and count. Okay.
Okay, thank you, counsel.
Thank you, Your Honor.
Good afternoon. May it please the court, Cheryl Ginsberg from Zingman and Associates on behalf of Cross Appellant 322 West 47th Street, HDFC. The lower court correctly denied Mr. Guarino's motion for summary judgment and correctly dismissed his time-barred claims, but erred in 2 important respects. First, the lower court should have ended the inquiry into Mr. Guarino's claims that he owned shares in the HDFC, based on his admission that he was never issued a stock certificate, and the undisputed evidence of the HDFC's audited record showing that stock was never issued and that no consideration was paid for the shares.
Does the law require that we have to have a stock certificate or just that the proprietary shares be signed?
It requires that you have to have a stock certificate. The stock certificate is the basis for which a proprietary lease is issued, not the other way around.
But that's an act that solely depends on you, right? Mr. Guarino got the proprietary lease and was willing to go forward, and you chose not to issue the stock certificate.
Well, it depends on him too. He was sitting there.
It depends on what?
It's his responsibility as well, because he was sitting at closing. He had an attorney at closing who was very familiar with all of the co-op's governing documents because he was simultaneously representing Ms. Benavides and Ms. Ho in the derivative action. Actually, one of his claims in the derivative action as well was that all documents to be signed by the co-op needed to have 2 directors or 2 officers sign those documents. And here he was sitting there at closing and there was only...
Counsel, then what do you do with counsel's assertion that this was a sale? So you have an affidavit or an affirmation from a lawyer that says he bought the apartment, I was at the closing. Are we just supposed to ignore that?
Well, there needs to be some evidence of payment.
But it raises an issue of fact at a minimum, doesn't it?
I don't think so, because I think he admits...
A lawyer's affidavit that says, I was at the closing and he bought the apartment doesn't raise any...
Well, Mr. Guarino from the beginning said, and the only documentary evidence in this case was that there was
documentary evidence and testimonial evidence that contradict each other, correct?
That's true, but that was only when Mr. Guarino sought to amend his answer years after the litigation commenced. So from the beginning, he was saying, I paid no cash. And it was only when we informed him that your security deposit was not actually $250 as you were alleging, that it was only $215, then he suddenly said, oh, I must have paid $35 in cash, which was very convenient because you can't track a cash payment. And if you look at all of the corporate records, including the records that were submitted under court order by Ms. Benavides, there is no record of $35 that was ever submitted. And the co-op's audited financial statements as well show that there was no new shareholder in 2009 at all. It lists the 3 shareholders in 2009 at the beginning, 3 shareholders at the end, and no new purchase of stock. The only documentary evidence that they have is that statement saying that the $250 security deposit was applied in full, no cash. And I think that the law also is very clear that if you don't have both a stock and lease, then any purported transfer is invalid. You need to have both documents. Mr. Guarino did not request a stock certificate for years afterwards, even though he knew that he didn't have one. The second error that the lower court made was permitting Mr. Guarino to amend his answer for a second time to add a collateral estoppel claim pertaining to an unrelated lawsuit from 2008. The lower court was correct that collateral estoppel requires a showing that the identical issue was necessarily decided against the party in the prior proceeding, and that there was a full and fair opportunity to be heard. However, the court improperly focused on only the second prong, finding a question of fact. The court should never have reached the second prong because Mr. Guarino failed to meet his burden on the first prong. He needed to show that the issue was material to the first action, essential to the decision rendered, actually litigated, squarely addressed, and specifically decided. The 2008 derivative action was an action between Benny Benavidez and Cindy Ho on the one hand, Martha Howes on the other, as to who was the proper director of the corporation. In the end, it was found that Martha Howes was the proper director. However, the pleadings in that action never mentioned the proprietary lease, never mentioned Mr. Guarino. Similarly, the decision in that action never mentions the proprietary lease, never mentions Mr. Guarino. The lease wasn't even signed until a year after the action was commenced. So if the decision, which found that there had actually been no contracts that were submitted, didn't mention the decision, it obviously was not squarely addressed or specifically decided as required for collateral estoppel to apply.
Thank you.
Thank you.
Give you 1 minute, counsel.
Thank you, Your Honors. Just three quick points. As to the payment issue, we have 3 sworn statements from the individuals who were at the closing, all who attest to, in addition to Mr. Guarino's, who attest to how he paid for it. We also have a receipt showing the full $250 were paid. As to the stock certificate, we do not think that it's required in this context. In fact, his proprietary lease entitles him to the shares and to the stock certificate. He seeks through specific performance conveyance of that. And cooperative ownership is a hybrid nature, and we think when it comes to the eviction of a long-term low-income tenant, the proprietary lease giving him possessory rights controls. As to the motion to amend, I simply would say that to date, the HDFC has not identified any legally cognizable prejudice or surprise. And we think on the merits that Mr. Guarino shows, at a minimum, that his amendments were not palpably insufficient as a matter of law. And in fact, we're dispositive, as I discussed in my opening statement. So with that, Your Honor, thank you very much.
Thank you, counsel. Cross Appellant, you got 1 minute.
I'd like to address a further point on the payment. Mr. Guarino also knew that Ms. Benavidez was not depositing the money that he allegedly paid into any account that was the co-op's account, that she was depositing into her own account, and he made no effort to make sure, if the money was actually paid, that it went into the co-op's accounts. I think knowing this, and his attorney certainly knowing this.
Why is it his responsibility to know where the money, what you do with the money that's given?
Normally, I would say no, but due to the fact that he admits that he knew that they were in the middle of litigation as to who was the proper authority, who could properly represent the co-op, and his attorney also knew that they were in the middle of litigation.
He told that they had the authority to transact, and he makes the payment. It's not his business what you do with the payment as long as you have the authority to collect it.
But he knew that they did not. He admits that he knew there was a derivative action. He admits that he received a notice from Martha Howes, the president of the co-op, telling him that
That's
neither
for
Ms.
trial
Benavidez-
fact, right? You say he knew.
He admits that he knew, so it's not a question of fact. He admits
All right.
it in his papers.
Thank you. Thank you all. Okay, Arch Insurance, you first.
Good afternoon, Your Honors. Robert Lewin from Stricken Levan. The lower court misconstrued the insured's obligations as a self-insurer under the self-insured retention, which is part of the policies in question. Self-insurance, as the court is aware, is a tool of risk management that has frequently been used in the last several years for insureds to manage their risks. Under SIRs, self-insured retentions, insureds are responsible for defense costs. They're responsible for losses within the self-insured retention, up to the limit of that. The court below misconstrued that. In this case, it's undisputed that Arch's obligations had not been triggered by exhaustion of the SIRs. That's undisputed. But what happened is, and why that happened is relevant to some of the claims we made, which I'll mention in a few minutes about successor liability. It's relevant because the Petrocelli electric companies denuded themselves of all of their assets. So at some point in time, they didn't care one iota about defending these claims. So what happened? My client, Arch, stepped in, took over these claims, defended them, paid losses, and was out a substantial sum of money, millions of dollars. And what the lower court did when confronted with this, said, oh, there's language in the policies that talk about you have, at your election, Arch can jointly participate with the insured in defending claims. Well, that's not what happened here. Jointly participating means that
that means you do it together, and they weren't doing it at all.
Absolutely. As Your Honor knows, those clauses are typically in insurance contracts to allow the insurer to come in and oversee, monitor, assist. That's not what happened here. There was a complete abandonment by the insured, which breached their obligations of good faith in the contract, which are spelled out.
Counsel, even assuming what you're saying is correct, did you document the specific amounts of costs that should be attributed to each of the Petrocelli defendants?
No, and that's why we moved for partial summary judgment on liability on this issue. The damage part hasn't been, but I believe it's all joint and several. And that's what my adversary spends a lot of time in his briefs addressing, which the court below never reached. But to me, it's a simple question. The named insureds are identified in the policy as 15 entities. They're equally insured under the language in the policies.
But isn't each insured only responsible for payment of the claims that were actually brought against them? How are they all responsible for every claim that's brought?
Because they're all under the same policy, and they're all equal in the same policy. They get the benefits equally, and they have the obligations equally. There's nothing in the policy that talks about divvying up amounts per.
Well, counsel, is there anything in the policy that actually says joint and several liability?
No, it doesn't say that in words,
word
but that's
there
how,
at all?
that's how they, my understanding, that's how it has been interpreted generally, that the benefits flow to each one and the obligations flow as well. There are many, as you know, there are many provisions of a policy which require the insured to do things. That's not divvied up by insured. It applies to all of the insureds when there are multiple named insureds. This is not a situation of additional insureds. That's a different story. This is a situation where they're named like they're the first named insured. They have equal responsibility. And this all goes back to what I said a few minutes ago. The whole reason my adversaries devote so much time to this issue goes to my third point, I guess, and I'll go back to the second one and again in a second, which is the successor liability point. I mean, I have to say that if this case isn't the classic case of a successor liability for summary judgment, it is impossible to imagine the case that is.
Well, isn't the issue of Alan Brightwise, because that's who the company is, Alan Brightwise, successor liability, isn't that currently being litigated in 3 other actions? So, I mean, should we be deciding this?
Well, I don't think any case, to my knowledge, none of those courts have decided it, and they're all involving different parties, not my client. And why it's relevant certainly here is the court below, as you saw, said it's an issue of fact. But I submit to you that you have a situation of transfer of assets, transfer of employees, transfer, they use the word migration. The defendants themselves use that word. Migration of customers, migration of contracts. There's a common ownership. I mean, as I said, these are the touchstone of successor liability. And if I was teaching a law school class, I think this would be the fact pattern I would use. And frankly, for the court to deny it below, I have to say, it would mean that there's no case that even is the symbol of successor liability that the court could ever grant summary judgment on. And that's not correct. And let me just, if I may, just...
I'll give you 20 seconds. It's late in the day.
Excuse me?
I'll give you 20 seconds.
That's all I need. There was one other claim that involves a little over $26,000 in premium that we also moved for summary judgment on. It was retrospective premium on an audit. The testimony of my client by an affidavit and the invoices are unrebutted, yet the court below did not grant summary judgment. We ask this court to please reverse and do the right thing on that. And just one other thing. If this decision is allowed to stand, I have to say it would be a roadmap for all insureds in this state to get SIRs and just walk away from their obligations. That can't be in the law. Thank you.
Thank you. Go ahead.
Please, the court. My name is Raymond Garcia. I represent the defendants. Apart from the histrionics of brother counsel, I think it's pretty clear that the contract does provide an option, which Arch exercised, to come in and defend the cases that Petrocelli Electric, who was going broke because of problems with the city of New York and otherwise brought on by the father's involvement with some schemes.
Yeah, that does getting indicted does definitely bring on a problem.
It did, but it didn't. The sins of the father weren't visited on the sons and the others. They were able to separate and manage that down. It didn't change the language of the contract, and the contract says we shall have the right but not the duty to participate with you. There is no evidence that PC ever refused to participate with the insurance company.
Is there any proof, excuse me, is there any proof that you did participate?
Yes, Your Honor. They sent people, they found documents, they participated in the defense. Their attitude was, based on an analysis, which they admit occurred, if you look at the record before Judge Crane, and if you look at the record that their briefs below indicate, PEC was thinking about this, they kept track, they projected, they made a business decision about how much they were going to spend relative to what the exposure was. The insurance company didn't like it. Their reasoning wasn't what they give here. Justice Crane found they were voluntary. Their reasoning was, we believe defending the merits of each of these will reduce our exposure to SIR. And what's an interesting thing there is the second part of the provision provides them an option to do that, but they ellipsed out the language. So the part of the clause that says, in the event of a claim or suit which our reasonable judgment may result in payment including allocated loss in an amount in excess of the self-insurance, and then has a provision...
Well, they don't care about the,
But that's not what they did. They literally are here on a record they contrived, which eliminated that language. The only thing that they put before the court by Judge Crane is the first sentence. And their position, Judge Crane said, you got to write it differently. She was right. Now, I appreciate where you're coming from to some degree, but there was no abdication of the obligation. There was a reasoned judgment about the expense of defending.
Wait a second. So you're saying that your client put in notices of appearance and appeared?
No, they didn't appear.
So then the only choice is default. You can do whatever you want behind the scenes, but unless you your client puts in a notice of appearance and appears, the action gets decided on default.
Your Honor, I appreciate that.
Did your client put in any appearances in any of these cases?
In all but 51 cases.
So they did put in.
There were some that they defended early on.
Okay, and they're seeking reimbursement for those cases?
They're seeking reimbursement for the fact issue that rises if we get there is going to be incredibly complex because you've got to unpack all that.
My point to you is that no one would say that if you didn't put in a notice of appearance, that they voluntarily agreed to join the defense.
No.
They had no choice in that circumstance because the only choices are put in a notice of appearance or defend. No matter how many paralegals you have behind the scenes, those are your only choices.
Yes, because you had there is an SIR, but above that, then it would go back to the insurance company, obviously. So they didn't want to risk defaults. My understanding is some of those cases were potentially worth more than the SIR, which happens.
Your
I mean,
Honor.
they're like an excess carrier in those
Your Honor, I'd suggest that the record on what the potential exposure is in those cases is non-existent. There was conclusory statements made. There was some anecdotal information presented. But there's no evidence in this record of what the reasonable basis was, if any existed, for a perception that these claims were over the SIRs. And I can tell you from looking at the releases, many of the cases were settled for $10,000 or $20,000, and the legal fees were enormous. So my client made a business decision about how to back out of it. And the record is pretty clear. We assisted. Business people worked with them. There's nothing in this that says the participation has to be lawyers and paralegals in court. And I'm not suggesting to you a scenario where it changes the SIR landscape, because there's 9 cases that deal with SIR decisions across the country, and they're generally about the participation of other insurance companies in the expense incurred. There isn't one like this. And what's fascinating about that is New York's a file and use state. So if they think this is a problem, it takes about 2 minutes to make a guy blue line the thing and file it, and he's done. So the great expense that he claims will occur because this case gets affirmed is wrong.
Thank you, counsel.
Thank you, Your Honor.
You get 1 minute.
Yes, thank you.
Counsel, can you address that point? What evidence did you put in to show that this would go above the SIR?
My understanding, Your Honor, is there was some serious claims.
No, I just want to know what evidence did you put before the trial court? Because otherwise, then you deny summary judgment.
No, Your Honor, with all due respect, I think there was evidence that the claims people at Arch were concerned that there were potential claims that could go beyond the XIR. I think that's sufficient. As you are well aware, no one can be sure what cases will turn into, and I believe some of these cases were substantially much more than $10,000, and that was not part of our summary judgment motion because that was not on damages. This was on liability. I do not believe
well,
we have to show...
Counsel, if you don't go above the SIR, there's no liability, correct?
But that's not true. There's a potential always that it could go above the SIR, and let me add to this. The fact of the matter is that we have to be concerned for the public. These were valid claims out there that people weren't paying, so we were protecting the insured as well as Arch. And there's a case that even says that. I found an Eastern District case that's cited in our brief called Royal Insurance, which does say that it's within the province of the insurance company to step in an SIR when the insured doesn't do what it's supposed to do. And if I just may add 2 more things quickly. Number 1 is their own financial statement, which is Record Site 45, they acknowledge these liabilities. They acknowledge their liabilities for the SIR, number 1. And number 2 is there's a statement in their own brief on page 14 where they say, and I'm just going to read this sentence and I'll end. Indeed, they say the following, quote, the SIR endorsement only covers Petrocelli Electric and only obligates Petrocelli Electric to repay Arch. They admit in their own brief that they have an obligation to repay Arch. That's why I submit to you the only issue really for this court is the issue about Brightway and having all the other defendants be responsible.
Okay. Thank you, counsel.
Thank you.
Okay, Worthy Lending.
Good afternoon. May it please the court, Richard Haddad for Worthy Lending. Worthy made a secured loan secured by the accounts receivable of its borrower. The contract gave Worthy the right, the absolute and unfettered right and discretion to give notice to the client, to the borrower's customers
Are you seeking money that was already paid to Checkmate?
Well, it's unclear. Certainly, the defense has taken the position that it was already paid, and certainly the lower court found that it was already paid. And the key flaw, the fatal flaw in that position, is that Article 9, Section 406A, says after receipt of notice, if you pay the borrower, you do not get a discharge. After receipt of notice, you may only pay the lender.
Counsel, did Checkmate say that to the plaintiff, no, pay us?
Well, we don't know exactly what Checkmate
Well,
said.
isn't that what Checkmate says? Checkmate's, I mean, is that a dispute that there was a direction from the person with whom they contracted to pay that contract directly, correct?
We suspect that may be the case, and that is precisely the problem.
Well, I mean, isn't that what the court found below? That there was a direction by Checkmate to pay
And they're
me and not you.
And they're not entitled to either give that instruction,
That's
and the borrowers...
between you
No,
and
it's not.
Checkmate.
Respectfully, it's not.
9607E makes it clear that it is not, that this party who has nothing to do with you has no independent obligation to you and only has an obligation to the party to whom it contracts. So if that party says ignore the notice, your remedy is to go against Checkmate, correct?
No, incorrect, and the reason is under 9...
I think that's clear.
Well, I think it's I don't believe so, Your Honor. I think it is clear that under 9406A and 9406C that the duty...
And then what do you say about 9607E?
I will say about 9... I think you have to read 406...
I've read them all, believe me, we all
together.
have.
I'm sure
So
I'm sure you have.
explain 9607E?
9607E does not provide the right. The right is provided under 9406 and the contract. 9607 provides the remedy. And what 9406C says is that their choice, when provided conflicting notices or conflicting instruction, is they are required to request further instructions from us.
I think that that's exactly what 9607 says, is they have nothing to do with you. We are not going to burden them with that obligation. You have to go to Checkmate and tell Checkmate, rescind that. That is what the UCC makes clear.
No,
They have no burden as to you. They have no obligation as to you. You are a stranger to them. And once their contractee says don't pay, the burden becomes yours, not theirs.
Now, respectfully, Your Honor, that ignores 9406C, which says that it's their obligation to request further information from us and then decide. And if we don't provide the further information, then and only then can they pay the borrower. They had three choices.
Counsel,
They could
is it
honor
a
our
problem
request.
for you that you did not assert 406 in your complaint?
No, the rights are 406. The remedy in the enforcement is 607.
Is 406 mentioned in your complaint?
Excuse me?
Is 406 invoked in your complaint?
Well, 406 is invoked in, the contract is invoked. And what Section 4K of the contract provides, at page 24 of the record, is that we have the right to provide notice at our discretion, at our own interest from time to time, as we want to compel the account party to pay the lender. They had three choices. They could honor our notice, which is what's required under 9406A. They could request further information, which is 9406C, or they could interplead the money and say, we don't know. The one thing they cannot do, the one thing that they're not permitted to do under the Uniform Commercial Code is to pay the assignor, because 9406A says if you pay the assignor, you cannot get a discharge of the obligation. That's the fundamental legal right. That's the error of the lower court. The error of the lower court was saying there's a difference between an assignment and a transfer. But the UCC says in 9102, official comment 26, that those two are the same, that a transfer of a security interest is to be treated as an assignment, and as the permanent editorial board of the UCC said, any court that holds to the contrary is incorrect, quote unquote incorrect. That's what was done here.
Okay. Thank you, counsel.
Good afternoon. May it please the court. I'm Glenn Berger, Jaffe and Asher, counsel for defendant respondent New Style Contractors, Inc. The court has it exactly correct. That is,
I just want to ask you,
Yeah.
one, did you get notice from Checkmate not to pay the assignee directly and to pay them?
my client went to Checkmate and said, what is this notice from Worthy Lending? And Checkmate said to them, pay us. We're having a dispute with Worthy Lending that we're terminating the relationship. And that's why they made the payments to.
Is there any fact issue as to that? Counsel didn't seem to think that that was in the, is that undisputed?
It's not disputed.
So once there's a dispute between the two of you, right, then the UCC, is it your position that the UCC says, in that case, you don't have any obligation to the stranger to your relationship?
Yes, Your Honor, I believe that it really boils down to, does 9607E mean what it says it means? There's basically in the complaint Worthy Lending is claiming rights as assignee in its borrower's accounts receivable, even though no assignment was given. The law is clear that assignment is not, a notice of assignment cannot exist independently.
We don't even have to reach that, correct?
Well,
Regardless of whether or not, whatever it is, once there's a dispute between the two of you, the contract, the account debtor, I guess, only has a responsibility to its own contracting party, correct?
Yes, to the contracting party, and in fact, had New Style asked Worthy Lending for the assignment, they would have had no assignment to give them. I mean, that's what it boils down to. There is a difference between a security interest. It's simply collateral. It's not ownership in the account. And just like any other assignment, if you pay the predecessor an interest, you haven't paid the right party. But if you're already paid.
No, but their contract says, with Checkmate, we get to, in our discretion, send out a letter to all your people. I mean, that's what Checkmate agreed to. So I think that argument is beside the point. It really is your argument as to whether or not you have an obligation to them prior to when there's a dispute between the two of them.
Your Honor, what they said is that they have an assignment. They don't have an assignment, and that can't exist independently. The notice cannot exist independently of.
I think the contract says we have the unfettered right to send a notice to your vendees requiring them to pay. I mean, you're not going to make Checkmate's arguments, right?
New Style is my client, yes. But vis-a-vis my client, New Style, they're not a party to that contract. The question is, does 9607 mean that there is no direct independent liability between a secured party and the account debtor? And I believe it means what it says. And of course, if Worthy Lending wanted to have an assignment, they could have easily gotten one. There's no danger here to commercial lending. They simply should have gotten an assignment and bargained for it, so they're not simply purporting to have an assignment.
Okay, thank you, counsel.
Thank you.
Thank you. To answer Your Honor's question, we did reference 9406 in the complaint at paragraph 17, 20, and 22. That's where we lay out the fundamental rights, and then the collection remedy in the cause of action is 9607. With respect to the suggestion that we needed to get something different or something in addition to a security interest, i.e. a quote-unquote assignment, the official comment 26 to 9102, as well as the 2020 of March last year, official guidance from the Permanent Editorial Board of the UCC says those claims, those two terms, are intended to
Although the
have
first
the same meaning.
counsel, although the first department has said something else, right? We've said
actually
something
not.
different.
Actually,
We have
that's not what
not?
the first department said. That's what the lower court said, the first department said.
Right.
That's what they say in their brief, the first department said. But when we actually read what the first department said in IIG, they said the plaintiff there could not recover on the accounts by virtue of the security interest because the contract required there to be an event of default in advance of the action, and no such event of default was pleaded. Our contract says the opposite. We don't need an event of default, and what 9607A says, it says, if so agreed, and in any event after default, we have the right to proceed. Well, we so agreed, so we didn't need to deal with the default. So the distinguishing factor, which I think is outcome determinative from the IIG case, is that there was a requirement to have a default pleaded. We did not have that. The lower court also said that there was a dispute between us and the customer about whether we were entitled to payment. There is no dispute pleaded. There's a debt pleaded, and that's a fundamental difference because you can't enforce a security interest unless there's a debt. It has nothing to do with a dispute. And the lower court, by finding the debt to be the equivalent of a dispute, was flat out wrong. And the policy compels reversal. Thank you, Your Honors.
Thank you. Thank you both. People versus Martin. Go ahead, Counsel.
Thank you, Your Honor. May it please the court, Michael Fernandez, on behalf of defendant appellant Wayne Martin. My firm, Winston & Strawn, is pro bono counsel for Mr. Martin, and I'd like to thank my colleagues Harvey Kurzweil and Jeannie Kang for their invaluable assistance in this matter. Mr. Martin is an African-American college-educated veteran who suffered from PTSD. He has completed 4 years of a 6-year sentence imposed in this case and was released on recognizance by a justice of this court roughly about a year ago. He has since reintegrated himself into society. Your Honors, my argument today is going to focus on the complete and total absence of probable cause stemming from police officers' observation of an African-American gentleman seated next to a white man in a park bench in Washington Heights.
Counsel, you'd concede that with the correct circumstances, the observation of a single transaction can be enough to create probable cause?
Yes, Your Honor, I do concede that. But here the issue is that what the officer observed was basically fleeting from equivocal hand gestures and an exchange of what appeared to be money. I think, Your Honor, that type of conclusory statement is insufficient to meet the officer's requirements for a probable cause. I think that...
Well, also that McKenna Park was a known drug location, that adds to it, does it not?
Yes, Your Honor, that does count, but that's not sufficient under this court's precedents in People v. Howard, which was written by Justice Ellerin, and People v. Wilson, and including other Court of Appeals precedents. So, Your Honors, it is relevant that this was a drug-prone location, and there is certainly testimony to that effect. And, certainly that's something that can be considered. But the issue here is that the officer simply saw Mr. Martin making a crushing motion and from a distance in what was a moving vehicle, and then saw what he thought was an exchange of money. For all that the officer knew, Mr. Martin could have been crushing aspirins, could have been crushing aphrodisiacs, could have been crushing anything. And so what happened here is that the officer saw those equivocal gestures and immediately decided that it would be appropriate to make an arrest rather than make an inquiry, right? The officer, and certainly under this court's precedents, what would have been appropriate for the officer would have been to approach Mr. Martin and inquire.
But again, aren't we supposed to consider the totality of the circumstances? So if the area is known as an area which is high volume drug trafficking, if the Detective Salas, I believe was his name.
Yes, Your Honor.
He was an experienced narcotics detective, and so he'd seen this kind of situation. Aren't we permitted to take all that into consideration in determining the probable cause
Yes, Your Honor, absolutely. That's
So what is it that throws it away and takes away the probable cause under those various circumstances?
certainly, Your Honor. I think the issue here, and is I would cite to Justice Acosta's opinion in People versus Garcia, which is basically you have unspecific testimony about what the motions were. The officer saw a crushing motion, he saw a small object, but didn't see any drugs, didn't see any indicia of a drug transaction. And unlike many other cases where this court under
Well, he saw somebody, what it looked like somebody handing him money for something that he was doing, so he did see that.
Yes, Your Honor. But there are cases like People versus Wilson out of this court from 1991, which is cited in our brief, where an officer observed an exchange for an unspecified object for money, and that was found to be insufficient for probable cause. And here, Your Honor, I would say that the officer didn't say that, you know, in many years of experience, he's seen a crushing motion, and that's led him to think that because of the crushing motion, that was the reason why. When asked at page 16 of the suppression hearing, why did he assume, he just said simply the location and the motion. But there's no testimony as to what about the motion is indicative of criminal behavior. That's completely missing in this record. You know, and the issue is that there's no indication that, for instance, there's nothing in the record that would preclude a conclusion that Mr. Martin was crushing something innocuous and engaged in a legal transaction. So given the...
Mr. Fernandez, tell me, you said that he served 4 out of the 6-year sentence, right?
Yes, Your Honor.
Okay.
Yes, Your Honor.
Tell me what the nature of the integration is into the community. What is he doing now?
So, in fact, I spoke with Mr. Martin yesterday. He informed me that he now has a job. He's going to be working at Housing Works. He has housing at Exodus Housing and is working with a housing specialist to obtain permanent housing. And Mr. Martin has continued seeing case managers, therapists, and psychologists. So he's been working to make sure that this time, there are no issues with his reintegration into the community and that it is a successful reintegration. So I think he's really returned back to normalcy in terms of everything that he's done.
Thank you. Thank you, Counsel.
Good afternoon, Your Honors. Jonathan Cancerero for the People. I think the critical factor here with respect to the suppression motion was the officer's testimony regarding what he observed before the hand-to-hand transaction, in addition to the totality of the circumstances. The officer testified that he observed defendant crushing an object with one hand, using his fingers into the palm of his other hand. Critically, the officer specifically demonstrated for the suppression court the motion that he observed defendant making, which was then followed by the exchange for money in a narcotics prone location, which the officer then concluded, based on his training and experience, including specific arrests for narcotics made at that location, that defendant was involved in criminal activity. Now, I know that my adversary points out that, or argues rather, that crushing motion was susceptible to innocent explanations. In our main brief, we note that he doesn't offer any, and then in reply, he says it could have been possibly crushing aspirin. Now, I don't know anybody who crushes aspirin in that manner, followed by an exchange for money in a narcotics-prone location. Doesn't seem like a reasonable explanation, therefore it doesn't seem
What did the officer say to connect it to narcotics activity, the crushing motion?
Well, it was the crushing motion itself. The unique motion that defendant was making was rather unusual, using the fingers of one hand to crush a small object.
But was that like to break up rock cocaine so that it could be snorted? I mean, did he say that?
He didn't say that, and I don't think he was required to say that. There's no requirement, certainly from this court's precedent, indicating that an officer is required to specify that level of detail in order to obtain probable cause. This is not a reasonable doubt standard.
So why isn't that an innocuous act? I mean, as we found in People versus Garcia, that was cited by Mr. Fernandez.
Well, Your Honor, as Your Honor mentioned, it was the totality of the circumstances. It's that unique manner of crushing an object into one hand, followed by a transaction of that object.
So if I want to break, if I want to break one of my health pills, for example, and, it's 12 o'clock, I need to make sure that I take one half and then the other half at the end of the day, which I do. and I crush one, I better not do it at 165th and Audubon, right?
Well, Your Honor,
I can only do that in certain parts of the city, you're saying?
you might not want to do that and then sell that object in exchange for money in a narcotics-prone location.
It could be that a guy asked me for a $20 exchange for a $20 bill, and we exchange. The exchange that the Detective Salas saw was an innocent, changing, breaking a $20 bill for somebody.
It might appear that way to someone, a layperson. It might appear that way to me. It did not appear that way to the officer who testified.
I know, but that's the problem, isn't it? I know he says totality of the circumstances, is not innocuous, is this, is that, but usually when you're unclear about the nature of some conduct, some questions get asked, right? Doesn't he have the ability to ask, what are you doing?
He could have asked that. He didn't need to ask that because he already had probable cause at that moment. And I would just point this court to page 15 of our brief, where we cite a trilogy of cases that support our position that the observation of a single transaction, even though it wasn't identified in exchange for money, in addition with the totality of circumstances, would provide an officer probable cause. And in those cases, we don't have the additional facts that we have here of the specific nature of the crushing motion that was made and the sequence of events that it was followed by that transaction. So I think that
tell me about the sentence. He already served 4 out of the 6-year sentence, and he's out on bail based on one of our judges' decision, correct?
That's correct, Your Honor.
I mean, he seems to be reintegrating into the community. You saw some of the things Mr. Fernandez said.
Well, certainly, Your Honor, there's no excessive sentence claim, so that would have no bearing on the suppression motion, has no bearing certainly on the other 2 points that...
Does it prevent the court from exercising its interest of justice jurisdiction and reducing the sentence to time served?
It would in this case. That argument wasn't raised by defendant in their main brief nor in their reply. Not really being raised at oral argument either, so I would respectfully request that this court decline to reduce the sentence in addition to affirming the judgment of the conviction. I see that my time is up.
Okay.
Thank you, Your Honor.
Counsel.
Thank you, Your Honors. As Your Honor explained, Justice Acosta, in People v. Garcia, the issue in that case was that by describing unspecified motions as furtive, the officers were making conclusory assertions that the conduct was suspicious. The officer's unspecific testimony does not support a finding of founded suspicion of criminal activity. Here, what we have is an officer basically seeing what he thought was a potential drug transaction. It sounds like a gut reaction, a hunch, and basically acting on that hunch. And I think that the issue here is that we have no evidence that explains what is underlying that hunch. It's as if, Your Honors, to give a very loose analogy, I filed a brief in this case. I cited to no cases, and I told you, take these conclusions on faith. They're right. Normally, Your Honors, you'd want to see the cases to understand how I reached that result. Here, the problem is that the officer tells us that he's concluded that there's a drug transaction, but doesn't get into the meat of why there's a drug transaction. He doesn't say that in his vast experience as a narcotics officer, he's seen 20 different instances where there's a crushing motion that was involved in a narcotic sale. And in fact, I would note that in all the cases cited by the prosecution, there's not a single instance where there's this crushing motion involved in a narcotic sale. So what we have here is basically an officer observing something, not really giving specificity as to what it was, and just simply saying drug-prone location plus motions. And Your Honors, I would submit that that's insufficient to sustain probable cause in this case, and would therefore ask that the court vacate the conviction and reverse. Thank you, Your Honors.
Thank you, counsel. Thank you both. Oh, Mr. Fernandez, please thank your firm for your services in this case. Thank you. Last is State of New York versus Brand.
Good afternoon, Your Honors. My name is Sam Roberts. I'm with the Legal Aid Society's Homicide Defense Task Force, and I represent the petitioner appellant Brighton Montgomery. May it please the court. Your Honors, in this case, the bond that the petitioner's father, Benjamin Montgomery, the obligor in this case, tried to post satisfied every single condition and public policy concern required of a partially secured bond. There was no question here as to the value and sufficiency of the security itself, 10% of the $150,000 bond amount. Benjamin Montgomery had a check, still has it a year later, for $15,000 that he is trying to offer to the court.
But what happens if the defendant absconds?
I'm sorry, I didn't mean to cut you
go
off.
ahead.
What happens is that Benjamin Montgomery loses $15,000, more money than he's ever had.
Which a lot of what was not his money, correct? I mean, he raised a lot of this online, so that $15,000 was not his money. This was just money that some of it.
No, Judge, this was money that was donated to him.
Donated.
It was the same money. It belonged to him. His right to it, his possession of it, was just as if he had worked for it, if he had won a scratch-off lottery ticket, if he had gotten it as a bequest from a distant relative. Choose any scenario. It was his money. He stood to lose it. This is a gentleman who was making...
Just the $15,000, or does he have to cough up $150,000?
He is on the hook for $135,000 extra.
Right.
And
So it's $150 minus the 15.
Correct, Judge.
Does the court have the right to inquire regarding the father's ability to come up with that money?
No, Judge.
Father's indigent, by all practical purposes, judgment proof, right?
Well, I would say that the reason that we have I think we need first to look to the definition of partially secured bond in the CPL. Justice Bybin below grounded her decision in a finding that the obligor's inability to account for the full six-figure sum was, as she put it, dispositive. But the law is dispositive. A partially secured bond, which is one of the newly mandated forms of bail required by the revised bail law, which we should remember is called the Bail Elimination Act of 2019, now allows defendants and their families, like the Montgomery family, who resemble the vast majority of criminal defendants in that they cannot readily afford six figures. They do not have the collateral. They do not have the assets. So the security here is precisely what is set by the court and what's required by the bond, the $15,000. Now, it is true that Brighton Montgomery's father, Benjamin, lives on a fixed income, but he testified without dispute that in the event, which is purely hypothetical, purely speculative, that his son absconded and did not come back to court, he would make every effort to repay that amount. He conceded in all candor that it would take him years, maybe decades to do so. But the issue here, judges, is not whether the city of New York gets to collect on a windfall in the hypothetical event of an absconsion. The issue is whether there is sufficient incentive in the features of bail to reasonably assure the principal's return to court. And here, the record leaves no room for dispute. Benjamin Montgomery risked losing money that, though he got from the online donations and the charity of socially justice-minded strangers, he stood to lose $15,000 that he will get back and will be a life-changing sum for him in the event that his son returns to court. And then he will labor under a six-figure debt for probably the remainder of his life. And as he testified at the surety hearing, again beyond dispute, even if the state is unable to garnish that money because he earns it as a result of his honorable service in war and now gets a veteran's disability check, even if the state is unable to garnish that amount, he's going to make attempts to pay it, and it will affect his life. It will affect his ability to get a loan,
Well, if he doesn't have any, if he doesn't have any assets, I mean, it's probably he's not going to be able to get a loan anyway.
Well,
I mean, I'm trying to I think it's very commendable that he stood up and he's trying to do all this. I don't misunderstand me, but I don't think it's a very realistic proposition to think that he would ever be able to pay back $135,000.
Judge, if that's the inquiry, though, and I see my red light's gone off, does that mean I've never done this?
could
before?
just
I'll give you 30 seconds to answer that.
If that's the inquiry, if you look beyond what the statute requires, of CPL 500.10 sub 18, and look to can the obligor account for the full amount, again, the vast majority of criminal defendants can't do it. You've converted a partially secured bond into a fully secured bond, and you've rendered the crucial revisions.
So you're saying that the new law is meant to prevent exactly this kind of situation?
Exactly, Judge.
Thank you, counsel.
Thank you.
Do we want to start where counsel left off? I mean, you have a situation where you have a new bail law. I mean, some people agree with it, some people don't. But the reality is, it's not so that the state gets a windfall from the defendant absconding. The question is, can we get him back into court just on the posting of the $15,000?
Your Honor, what was set was the partially secured bail bond. And under the law, justifying affidavits apply to all bonds, whether they're secure or partially secured. And Justice Biden properly exercised her discretion in determining, one, to set bail in this case, and two, in disapproving the partially secured bail bond.
But didn't she basically convert a partially secure bond into a fully secure bond by focusing on the $135,000 that the defendant could not come up with?
No, Your Honor, because the law requires that for every bond, there has to be a justifying affidavit. And the court is allowed, under the law, to look at any matter inside that justifying affidavit. Mr. Montgomery has to swear, not once but twice, in the justifying affidavit that he will pay to the people $135,000. The court, the surety review court, is not compelled to take at face value Mr. Montgomery's promise. She could actually look behind that to see, is there any actual value? And just by analogy, the surety review court is not required to be like Linus, sitting all night in the pumpkin patch, waiting for the great pumpkin to appear because it is a sincere pumpkin patch. Mr. Montgomery could be very sincere. He could have a great record, service to his country. However, the great pumpkin is not coming, which would be the $135,000. The reason,
counsel, it's your position that that statement in his affidavit, that I will pay back the $135,000, after the 5 or 6 or 7 day hearing, Judge Biden was entitled to disbelieve that sworn statement in his affidavit?
she was entitled to see if that promise, if he is reliable. There's a difference between credibility. No one is saying he's not credible. Is he reliable? Can you depend upon him? Is there confidence that somehow he could come up with $135,000? And he had no plan for it when he testified to that. He was quite candid on that. I don't have the money. And yeah,
well, he could be paying a certain amount for the rest of his life. I mean, what his position was, of course. I mean, he's indigent. He's getting Social Security, a veteran's pension. He's not going to come up with $135,000 by going to the bank. He's going to take the rest of his life, but nevertheless, he's showing a willingness to pay it.
Yeah,
this is not sufficient.
No, it is not, because it doesn't provide a sufficient incentive for the defendant to appear in court. He's like, okay, my father at most, he's now 65 years old. He hasn't been gainfully employed in 17 years. Maybe If he makes little increments, he'll pay $1,000 over 20 years before he passes away. That's hardly an incentive for the petitioner to return to court to answer
What
charges on the
about,
murder
what
side.
about if he comes back and reports to trial and doesn't abscond, his father will keep $20,000 or $15,000 that are going to change his life?
The record clearly established and was within Justice Byben's discretion to view that $15,000 as not an actual loss to the father. Mr. Montgomery truly is a risk-free obligor here. Not only
But the $15,000 will go to him, regardless of whether he got it through crowdsourcing or any other way. It's his money.
But the loss of it is not enough of an incentive for the petitioner to return to court.
So you don't think that somebody getting a life-changing amount of $15,000 because it's life-changing because this is a guy getting a couple of $1,000s a month in Social Security and veterans pension. $15,000 is an incentive. I mean, that's a large amount for someone without income.
But it is not an abuse of Justice Byben's discretion upon reviewing all the factors to determine, no, it could be viewed differently. And especially in this case where Mr. Montgomery, he scrimped and scraped and was able to put up $5,000 as part of that collateral. But then he got a windfall. He raised out of an unknown amount of unverifiable online donors $20,000. So he was able to redeem the jewelry that he
I know much.
He's out nothing.
See, I know that a lot was made out of the crowdsourcing and how the money was obtained, but clearly it was obtained legally, and the money is his. Whether he got it through donations or crowdsourcing, I don't know that going into the source of the money creates less of an incentive to return if the money ultimately inures to you.
The court is allowed to look at the source of the collateral, just as in Preston, as in People v. Robinson, as in People v. McIntyre. So just because there's a familial connection here between the petitioner with his father, they could still look to see, is there an actual loss here? I don't think Mr. Montgomery and the petitioner are going to lose any sleep if Hello Kitty loses $5 or Paddington Bear.
Okay. Thank you, Counsel.
Okay. All right. Thank you.
Okay, Counsel, I'll give you 1 minute.
Thank you. Justice Bybin, on the record, said she did not dispute the veracity, the truthfulness of Benjamin Montgomery. Justice Neubauer, sitting as a writ court, stated at further length how Benjamin Montgomery showed grit and was in fact more suitable than most obligors. Unlike an obligor who stood to, say, lose his job, to suffer complete loss of income, Benjamin Montgomery, as Justice Neubauer noted, would have his income continue in perpetuity with modest increase over time. Benjamin Montgomery testified, I believe that's in the record, that he would be able to pay several $100s a month. It might take him 20 years. But again, we go back to the core consideration. How does this affect his life? Hugely. Consider that Benjamin Montgomery would have to lose not only his $15,000, but as Ms. Ante has just said, the money, the $5,000 that he scraped and scraped. Being poor does not make him the giver of illusory promises. It does not make him a liar. And the inquiry is, would absconsion affect this family's life? And the answer is clearly yes.
Okay. Thank you.
Thank you.
Thank you both.
I'll turn this off.